We understand that the Minister is here and will be joining us very shortly. And then, of course, we can kick off our program for this morning. Thank you so much for being here once more. If you can please just get settled and, of course, commence with today's proceedings. Thank you so much once more. Morning once more. I've been informed that the Minister will be here very shortly. I think we can still mingle and interact a bit, but we should be beginning our program very shortly. Thank you so much for being here once more. I hope everybody got a cup of coffee, a cup of tea, and yes, thank you so much for being here once more. To receive our Minister for Information and Communications Technology, that's Honorable Dr. Peya Moshelenga, as he makes his way into the conference venue. And while we remain standing, perhaps we can take this moment to observe the national and African Union anthems. Please remain standing here.
Namibia, land of the brave freedom fight, we have won. Glory to their bravery, whose blood waters our freedom. We give our love and loyalty, together in unity, contrasting beautiful Namibia, Namibia, our country, beloved land of savannas, hold high the banner of liberty, Namibia, our country, Namibia, motherland, we love thee. Let us all unite and celebrate together the victories won for our liberation. Let us dedicate ourselves to rise together to defend our liberty and unity. Oh, sons and daughters of Africa, flesh of the sun and flesh of the sky, let us make Africa the tree of life.
Thank you all so much. You may be seated here. It is a very cold, cold morning here in the capital. Firstly, a very good morning to you all. How are we feeling today? I said good morning. Good morning. There we go. Of course, we want to welcome, that is Honorable Dr. Peya Moshelenga, Minister for Information and Communications Technology, for taking the time out to be here this morning. We also, of course, acknowledge that is the presence of Commissioner Topsy Sono, who is, of course, that is the Special Rapporteur on Freedom of Expression and Access to Information in Africa, representing the African Commission on Human and People's Rights. I also see our Executive Director within the Ministry of Information and Communications Technology, that's Dr. Audrey Mate. Of course, furthermore, you see the UNESCO team, Mr. Musa in our presence as well. Thank you so much for being here this morning. We also, of course, have our gracious hosts, that is Ms. Freya Grunhagen, Director of the Friedrich Ebert Stiftung Institution, who, of course, through Fesmedia Africa, put this wonderful conference together. And everybody else present here this morning, representing your different organizations, institutions, thank you all so much for being here, and we truly appreciate it. Can I please have a big round of applause for each and every one of yourselves here? Of course, many of you have come from very far and also very near. Firstly, welcome to Namibia. Welcome to the land of the brave. Many of you are coming back after a very long time. Many of you are coming back from neighboring South Africa. We also like to call it the land of consistent electricity supply. So welcome to our South Africans this morning. I'll of course be failing in my duties this morning if I don't acknowledge the presence of Hopewell Chinono as well, renowned veteran journalist of Zimbabwe. I had the pleasure of meeting him yesterday briefly during our dinner. Mr. Chinono, welcome to Namibia. We truly appreciate you being here and of course your presence and contribution to this conference. We can't wait to see. Thank you so much for being here this morning. Please, another round of applause for him as well. Now, this regional conference takes place with the support of a number of institutions. You can see the logos on the sides here of the main poster. Your UNESCO's, the Namibian Media Trust, and of course, that is the ACHPR, the African Commission on Human and People's Rights. Firstly, another round of applause to them for, of course, assisting in putting this regional conference together. Now, without further ado, I'm told I talk a lot, so I'm going to try my best to leave the talking to, of course, our wonderful speakers, our panelists, our conveners, our rapporteurs, everybody who's really contributing to this conference. Thank you so much for being here once more, and we truly, truly appreciate your presence and participation on this very important occasion. Without further ado, please allow me to welcome to the fore, that is Ms. Freya Grunhagen. She is, of course, the director of the Friedrich Ebert Stiftung, the Friedrich Ebert Institution office here in Namibia. She also oversees, that is the Fesmedia Africa, which is a regional media project of the Friedrich Ebert Stiftung. And of course, they've put together this wonderful regional conference for us. Please give your hands to Freya Grunhagen.
A very good morning. Let me start with that. Director of Ceremonies, Mr. Ndishishi Hamufungo, our conference moderator from NBC. Honorable Dr. Peya Mushelenga, Minister at the Ministry of Information and Communication Technologies in Namibia. Honorable Commissioner Owina Girisha Topsisono, Special Rapporteur on Freedom of Expression and Access to Information in the African Commission on Human and People's Rights. Honorable Nima Lungangira, Member of Parliament, Tanzania. Executive Director in the Ministry of Information and Communication Technologies, Dr. Audrey Matte. Mr. Jafar Musa Al-Kadum, Head and Representative of UNESCO Windhoek Office. Ms. Zoe Titus, Director of the Namibian Media Trust. There you are. Distinguished delegates from 16 African countries, distinguished online participants, members of the media, all protocols observed. It is my great pleasure and my honor, I feel deeply, deeply honored to welcome you to the Fesmedia Conference on Information and Communication Rights in Africa today. Under the themes Digital Rights, Access to Information and Human Rights, co-hosted by the Special Rapporteur on Freedom of Expression and Access to Information in the African Commission on Human and People's Rights, Honorable Commissioner Topsisono, and in partnership with UNESCO Windhoek Office and Namibian Media Trust. After very many weeks of preparation, we are finally meeting 48 participants from 16 countries. And yes, I think this is a round of applause, really. And 30 Namibian participants, most of them being our partners, esteemed long-standing partners here in person, and hopefully many more participants online here from all over the globe joining us. Against this background, I really would like to open the conference on a note of appreciation and sincere thank you. The fact that you made it here clearly is an indication of your commitment and certainly also of the relevance of the conference. We all know many of you have been traveling many, many hours to come here. We were being told that some of you actually had invitations and commitments in other parts of the world, but actually decided to come here instead. And of course, 2.5 days is a lot of time, and you made that time out of your busy schedules. So I wholeheartedly thank you for this commitment that you are displaying. It really underscores the relevance and timeliness of our conference. Apart from you, the participants, I feel deeply gracious towards all those who have made this conference see the light. I would like to start with the Special Rapporteur for ATI and FOE. Please allow me to use the abbreviations, otherwise we keep on talking for too long. In the ACHPR, Honorable Commissioner Gerisha Topsisono. Thank you so much for co-hosting with us. We are very, very honored and also very much looking forward to whatever is coming up during this conference. Really, we are most excited to have you here. And of course, also for making time to come here and attend for the whole stretch of this conference. So already now your commitment has taken that conference to another level. So thank you so much. I would like to thank wholeheartedly our partners, UNESCO and NMT, Namibian Media Trust, for partnering with us, for having been a wonderful and long-standing partner, especially NMT, assisting with all the preparations and giving valuable advice. Thank you so much. Honorable Minister of ICT, Dr. Payam Moshelenga, you are honoring our conference with your presence and with giving the keynote speech. Thank you very, very much. And also for your assistance in soliciting the visa exemption that has really facilitated the process enormously. Thank you so much. Thank you to all the speakers and conveners. We will see more of you during these days. Thank you for agreeing or even volunteering to take on that extra work. You're very appreciative. And of course, last but not least, the conference preparation team, spearheaded by Dixon and Maya. They have been working hard together with our consultants, together with service providers, to make this conference see the light. They did a tremendous job. And yeah, thank you very much for pulling through. We are here. We are here. We are meeting. We made it. So at the heart of our conference, there will be a broad spectrum of issues relating to human rights in the digital age, with a very particular focus on access to information and freedom of expression. We will strive to look very closely at the positive and negative effects of digitization on communities, societies, politics, and the world at large. Obviously, this is not only an African, but a global debate. All over the globe, some effects of digital technologies have been grave, and they appear to be very similar, irrespective of which region you look at. Our conference's focus, however, will be solely on the effects of digitization in Africa. We deliberately provide the space, and a lot of space, for a comprehensive analysis of the state of information and communication rights in Africa, in terms of both opportunities and challenges associated with digital technologies. Let us have a brief look at some of those issues. We will be discussing them a lot, but it's worthwhile having a brief look at them now. Regarding the opportunities in Africa, it has frequently been argued that the advancement of the internet and social media platforms has actually opened up new avenues for democratization in Africa. The new technologies have provided new opportunities for ordinary citizens to access information. They have offered new platforms to disseminate information, express your view, citizen journalism. In many countries, technology has facilitated political mobilization and organization of protests and strikes. And all of these developments have been politically relevant, no doubt. However, when turning to the negative side, we immediately realized that this list is a little bit longer. In fact, digital technologies have been posing serious challenges to participatory democracy and human rights in Africa. In many countries, undemocratic regimes have used digital technologies to enforce political control, surveillance, censorship, thereby undermining free speech and infringing on individuals' rights to privacy. Especially in times of election and unrest, some African regimes have frequently resorted to shutting down the internet. Moreover, access to technology in Africa is less universal than in other parts of the world. Power politics, weak infrastructure, low affordability, all of them remain enormous challenges. Africa has the lowest penetration rate in terms of internet penetration rate in the world, with only 43% of the population having access, and some countries having rates as low as only 2%. Infrastructure challenges make it difficult to provide access to remote areas. Additionally, the cost to internet access is high. Those, however, who are not connected are implicitly excluded from all these benefits and opportunities mentioned above. Thus, the digital divide is violating basic principles of democracy and social justice. This is equal opportunity and inclusivity, thereby limiting the potential positive impact of digital technologies on access to information, on freedom of expression in Africa. Misinformation and disinformation campaigns have posed additional challenges to democracy in Africa, with false information and hate speech being easily and speedily proliferated through social media and messaging apps. It has been used, amongst others, to spread propaganda, incite violence against politically dissenting voices, socially vulnerable groups. To combat these issues, governments and civil society in Africa have put in place various measures, including the establishment of fact-checking organizations, media literacy campaigns, social media regulation. That is great. There is a lot of achievement. However, then again, social media regulation can easily be misused to stifle dissenting voices. Thus, the advancement of digital information and communication technologies has posed profound challenges to democratic processes, social cohesion, and even peace in Africa. There cannot be any doubt that it needs an equally profound and comprehensive approach to meet these challenges in a way that is conducive to promoting democracy. One that involves all levels: treaty bodies, governments, civil society, communities. And this is why we are here today. It is because FES, Friedrich-Ebert-Stiftung, and its partners, we are bound together in the firm belief in the importance of inclusive, comprehensive dialogue. It can never be one level alone, one stakeholder alone, but only the joint efforts and a broad variety of views, perspectives, learnings, experiences that will enable us to advance further the course of democracy and human rights in Africa. So for the next 2.5 days, we want to jointly analyze the situation, exchange views and learnings, collect ideas on how we can promote information and communication rights in Africa in the digital age. From the depth of our heart, we, Fesmedia Africa, hope that these discussions, the exchange and all our planning will not stop when this conference will end on Friday. Rather, we hope it will be taken to yet another level, which will see increased regional cooperation between civil society, governments, treaty body, especially the ACHPR. To the extent possible, Fesmedia Africa commits itself to supporting any future efforts to develop this dialogue further. So in this regard, when looking back, it is safe to say, yes, a lot has been achieved in Africa already. I would like to explicitly mention the one success story that we will also be discussing during the conference, Africa's gift to the world, the International Day of Universal Access to Information. I think we can all be so proud about this achievement. Again, how has it been achieved? It is an excellent example of the potential leverage that can be achieved through concerted efforts by civil society, governments, ACHPR. Obviously, a lot more needs to be done. Democracy and cooperation are, as we all know, not the easiest and smoothest path to walk on. They do need advocates who are committing to advance their cause. Democracy needs Democrats. I'm not getting tired to quote Friedrich Ebert here. And I want to do that because all of us in this room, in this regard, we are Democrats. We are driven by values relating to democracy. We are deeply aware of the importance of information and communication rights for prospering democracy. So let's stick together, let's work together. And on this note, I wish us all an insightful and exciting and fruitful conference. I thank you.
One more round of applause, please, for Freya Grönhagen. Of course, she is the resident representative of Friedrich Ebert Stiftung here in Namibia, as well as the director of Fesmedia Africa. Just to perhaps provide a bit of more background to Freya, she's been in the country since 2019, holding these respective positions. And Freya, I must say, on a rather sad note, you have a few more months left in Namibia, but this is certainly part of your legacy. And just once more, big ups, kudos to you and the team for putting together this wonderful regional conference here. Now, you would also observe to my right or your left, we have a lady, that's Selma Moses. She's our sign language interpreter for the duration of this conference. Of course, just making sure that the message does get across to all pockets of society. So please, Selma will be relying on all of us to, of course, speak clearly and that she can translate our message. We also have the Namibian National Deaf Association in our presence this morning, and we certainly welcome you to this very important conference and certainly look forward to your contributions as well. Our next speaker on today's program is Zoe Titus. Of course, Zoe Titus is the director of the Namibian Media Trust and the current chairperson of the Global Forum for Media Development, which is the biggest global community of media development and journalism support organizations. And GMD works collaboratively to sustain journalism as a public good. Zoe is also a former regional director of the Media Institute of Southern Africa and also chairs the African Platform on Access to Information. Ladies and gentlemen, Zoe Titus.
Good morning. Allow me to acknowledge the established protocol. Firstly, thank you very much, Freya, for the opportunity for the Namibian Media Trust to partner with Fesmedia Africa for this conference. I think that this is evidence of our common commitment to promoting equitable access to information and communication rights for all people. Namibia holds a very unique position within the global community, particularly in the realm of free expression policy making. It is in Namibia that pivotal milestones have been achieved, shaping the landscape of information and communication rights, from being the birthplace of the Windhoek Declaration in 1991, which led to the United Nations declaring May 3 as World Press Freedom Day, to the African Charter on Broadcasting in 2001, and most recently, the Windhoek Plus 30 declaration that recognizes information as a public good. Furthermore, it was here, again, in Windhoek, that the seeds were planted for the African Platform on Access to Information, or in short, ACHPR Declaration, which is a significant step that led to the establishment of the annual celebration of the International Day for Universal Access to Information on September 28. I think that it is, or I'd like to think, that it is therefore by no chance that this discussion here over the next few days on information and communications right is starting here in Windhoek. Freya has articulated very succinctly the galvanizing power of access to information. She has also spoken about the centrality of the internet and how it has broken down barriers, how it is empowering individuals from different backgrounds to access information and a wealth of knowledge that enables informed decision-making, active participation in society, and personal growth. But challenges persist in ensuring equitable access to information and the enjoyment of communication rights. Among these, the digital divide, limited digital literacy, this misuse of technology that may hinder marginalized communities and continue to perpetuate inequalities. So this conference, I believe, aims to address these challenges by exploring innovative strategies, policies, and collaborations to bridge the divide, enhance digital literacy, and protect digital rights. I think we should make the attempt to agree on a few fundamentals. Firstly, that it is our governments that have the responsibility to safeguard the free expression rights of their citizens and enable meaningful participation in public life through access to information online and offline. This requires a conducive environment for a free, independent, and flourishing emphasis on flourishing news media and an engaged and resourced civil society. But governments, media, and civil society alone cannot achieve this. The private sector, a critical driver of development, and even those that we purport to represent, are often absent from these important conversations. It is time, I think, that we recast our alliances and reassess our advocacy interventions. It really is my sincere hope that over the next 2.5 days, that our discussions transcend mere affirmation of shared perspectives. We have, after all, some of the brightest minds and the strongest advocates on freedom of expression and information rights right here in this room. So instead, I appeal to you that we focus our efforts on developing a concrete roadmap that will shape the future of information and communication rights on our continent. But equally, we must review our framing of community to show the inclusivity of the most marginalized amongst us. Just last week, during a consultation in Johannesburg on digital rights in Southern Africa, we were reminded, I don't see you, but I do believe it's you who made this comment, that for the majority of us, technology makes things easier. For persons with disabilities, it makes things possible. The week before, we launched in Namibia a project where a member of Namibia's Shack-Wellers Federation drove home their demand for being included in policy decisions that impact on their lives through citing their slogan, "Plan with us, don't plan for us." It is often necessary, I think, that we are reminded of the convictions that drive our advocacy, our collective desire to advance a more just, inclusive, and representative world. The challenge is clear. And only with collective action can we build a more inclusive and democratic society where everyone can exercise their right to access to information, participate fully in public discourse, and contribute to creating a more just world. I thank you.
Zoe Titus, ladies and gentlemen, as she takes a seat. It is indeed a collective responsibility, and as Freya and the team have done so in really reaching out to the plethora of institutions, organizations, activists, etc., that of course exists in ensuring that information and communication rights in Africa are protected and beyond its borders as well. So once again, thank you all so much for being here this morning and for, of course, participating in this very important regional conference. Now, moving on with our program this morning, we also have a statement by, that is Mr. Jafar Musa, Mr. Jafar Musa Al-Kadum. He is, of course, the country representative of UNESCO and heads the UNESCO Namibia office, also a key partner of this conference and general media landscape in the country. Please put your hands together for Mr. Musa.
Thank you very much, Director of Ceremonies, and I see that he struggled to pronounce well my name. Excellent. Again, Director of Ceremony, Mr. Ndishishi Hamufungu, Honorable Pea Mushelinga, Minister of Information, Communication Technology, my dear co-chair of the 2021 World Press Freedom Day Conference. We use this is how we agree to call each other. Still, dear co-chair. Ms. Freya Gwenhagen, Fesmedia representative, resident representative and Fesmedia Africa director. Honorable Commissioner Girisha Topsi Sono, thank you for being with us. Merci beaucoup. Honorable Nima Ligangira, Member of the Parliament of Tanzania, Dr. Audrin Amat, Executive Director of the Ministry of Information, Communication Technology of Namibia, our dear Ombudsman, thank you for being us also here. Ms. Zoe Titus, Director of Namibia Trust, distinguished invited guests, member of the media, ladies and gentlemen, online participants, all protocol observed, good morning and bonjour à tout le monde. It's an honor for me to share this remark at the opening of this conference on information and communication rights in Africa. It is equally a pleasure for me as the UNESCO representative to Namibia to join you, long-standing partners of UNESCO promoting freedom of expression and access to information, especially in this place of birth of the 1991 Windhoek Declaration and the 2021 Windhoek Plus 30 Declaration. We were not sitting together with Zoe to write the speech, but she did mention that, and thank you, Zoe, for recording and put the scene for all that. And indeed, it is very difficult to address you, this audience, which is very knowledgeable on the importance of enhancing freedom of expression and freedom of the press for deepening democratic participation in public life and for strengthening democracy, good governance, and development in Africa and in the world. You know already that as a full part of its mandate since its creation, UNESCO has been promoting, advocating for free flow of ideas and access to information worldwide. In recognition to this, in September 2015, the UN General Assembly assigned UNESCO as the custodian UN agency for the global monitoring of Sustainable Goal SDG Indicator 1610.2. I think that we all know about this, which aim to actually advance and support a number of countries to adopt and implement constitutional, statutory, or policy guarantees for public access to information. This is very relevant to our meeting and important. The rise in promulgation of access to information laws in recent years has provided ample materials to identify trends and assess their trajectory. The number of access to information laws globally grew from only 14 in 1990 to 137 in 2023. This growth shows that real progress has been recorded in terms of binding laws and policy giving individuals a right to access information held by public authorities. Allow me in this context to congratulate Namibia for having kept its commitment and has expedited the adoption and promulgation of the much anticipated Access to Information Law in 2022, thus joining what we call the SDG 16.10.2 club of today 137 other member states. These member states recognize that the right to information is not just a fundamental human right, but it is an essential factor in strengthening democracy, good governance, and development. The Namibia then commitment and demonstration indicates that they continue to strengthen the culture of democracy in this country, good governance and free flow of information, as stated in both the 1991 Declaration, Windhoek Declaration, and the 2021 Windhoek +30 Declaration. Director of Ceremonies. We all understand that what cannot be measured can hardly be improved. Designating UNESCO as a custodian UN agency to report on SDG 16.10.2, I'm sorry for that number, but we understand what it is, of the Agenda 2030, allow the organization to go beyond just monitoring the quality and number of access to information laws. During recent years, UNESCO has produced 3 surveys on public access to information and SDG indicators 16.10.2. We are pleased and encouraged to acknowledge the increasing number of member states that participated in these surveys. Indeed, in 2020, more than 60 countries participated in the survey, while in 2022, this number was more than 120. These reports are available on UNESCO website. The surveys and the built-in monitoring aspect also serve as a means for member states to learn from other states, thus motivating them to improve their respective legal frameworks, implementation and enforcement. For example, good practices collected from Côte d'Ivoire, Indonesia, Mexico, Sierra Leone, Tunisia, or Uruguay provide valuable lessons on how information collected during the monitoring help to strengthen enabling environment of access to information. With this in mind, I'm pleased to inform you that UNESCO is assisting the African member states in strengthening the African network of information commissioners. The network unites 14 today. We hope the number will increase and Namibia will join. This unites 14 African regulatory authorities composed of information commissioners, ombudsmen, and other regulatory authorities, including transparency councils or boards responsible for protecting, promoting, and ensuring the respect of the right of access to information within their respective jurisdictions. The main aim, of course, of this network is to strengthen the right to information legislation and implementation in the continent. Following the request from the network, UNESCO is now supporting the development of a strategic plan for the ANIC network and provided technical support in the network's capacity development, communication, and collaborative work. Furthermore, UNESCO has launched an online training resource in 4 official UN languages on access to information laws and policies and their implementation. The online trainings resources is being used to train staff of the African regulatory authorities and other stakeholders in upholding and strengthening the right to information. In the same context, UNESCO is convening next week a regional meeting on information in Nairobi, Kenya. I think we have a colleagues here from UNESCO Addis who can give more information on that. The meeting actually will highlight the status of access to information in Africa, implementation of access to information laws in Africa, strengthening institutions of information commissioners in general, and the African Network of Information Commissioner in particular. Director of Ceremonies, distinguished audience. Since its establishment by the UN General Assembly, the celebrations of the International Day for Universal Access to Information on 28 September every year provide a powerful platform for collaboration with stakeholders to raise awareness and advocate the rights to information at the national, regional, and global level. In closing my remark, it is my sincere wish that this conference formulates new ideas to strengthen the promotion of information and communication rights in Africa, build closer cooperation between civil society, development actors, and government partners with relevant regional mechanisms at the nexus of human rights, technology, and development. This nexus is also of an importance, thus empowering people to enjoy their right to access information. Un grand merci à vous tous. Muito obrigado. I thank you for your attention.
There you had it, of course, Mr. Jafar Musa Al-Kadum, country representative and head of the UNESCO Windhoek or UNESCO Namibia office. Once more, a big round of applause to him, please. And you may have heard several languages during his speech there. Of course, Mr. Musa also speaks French, he speaks Portuguese, he speaks Bahasa Indonesia, as well as you have a solid knowledge of, that is, the Spanish and the Kiswahili languages. Yes. Very much indeed. So, of course, for our audience who would like to, of course, participate in this conference via the French language, you can, of course, just put your hands up, and we will, of course, provide some headphones for you if you feel more comfortable in the French language. Just to staying, of course, with the program and just considering the number of key speakers we have this morning, the next guest is, of course, our guest of honor this morning. She is Commissioner Garesha Topsy-Sono. Just perhaps before she comes to the fore, maybe to give a brief background in terms of who Commissioner Topsy-Sono is. She joined the AU Commission in 2021. She is currently the Special Rapporteur on Freedom of Expression and Access to Information. She's also the Vice Chairperson of the Working Group on Extractive Industries, Environment and Human Rights Violations, as well as a member of the Working Group on Death Penalty, Extrajudicial, Summary of Arbitrary Killings and Enforced Disappearances in Africa, and a member of the Resolutions Committee and the Advisory Committee on Budgetary and Staff Matters. Now, Commissioner Topsy-Sono is also a lawyer with great expertise in international maritime law, and she currently works as a parliamentary counsel in the Attorney General's office. And of course, we can go on and on about her impressive resume, but interestingly enough, she's also proficient in French. So you can expect a few French words as well. Do stay with us.
Thank you very much. So, Honorable Minister of Information and Communications Technology of the Republic of Namibia, Dr. Peya Mushengenga, Ms. Freya Grenhagen, FES Namibia Resident Representative, Ms. Zoe, Director of Namibian Media Trust, Mr. Musa, Head of Office and Representative of UNESCO, Member of Parliament of the Republic of Tanzania, Ombudsperson, and those who are online. Ladies and gentlemen of the Information and Communication Rights Fraternity, ladies and gentlemen in the booth, I am honored to be speaking to you at this distinguished event, whose impact will be felt throughout the whole continent, and hopefully by generations to come. Information and communications rights are one of the fastest developing human rights issues of our modern times, and this regional conference is a testament to that. 20 years ago, when the mandate was set up of a Special Rapporteur on freedom of expression and access to information, it was scarcely conceived that information landscape would have changed so much. Back then, the biggest issues concerned the closure and ban of independent media and the occasional arrest of journalists. Today, we speak of more advanced approaches to shut down access to information and inhibit free expression within the law. As I speak to you today, the threats to information and communication rights in the continent expand ever so increasingly. Just recently, the story of a notorious team of Hohe broke out. A group of reporters went undercover to investigate and expose a disinformation mercenary company known as Team Hohe. The team leader confirmed on camera, unbeknown to him, that he and his team had interfered in 33 elections and won 27. The investigation reveals that the company uses a technology called AIMS, which is pretty much a software that weaponizes social media to spread targeted disinformation online. The system has control of hundreds of thousands of bots with profiles on social media and other online platforms. These bots are sophisticated, multi-layered, and resemble human beings in their online interactions. Through their mass dissemination technology, they spread false information. This not only interferes with individuals' rights under Article 9 of the African Charter, but also materially alters the outcomes of elections in violation of Article 13 of the Charter. This is just one isolated example of the challenges to information and communication rights on the continent. Many other challenges still persist, and I will need much more time to talk about that. Honourable Minister, ladies and gentlemen, it is because of the vastness of our challenges that it is important to convene such a forum, because many questions remain unanswered. How do we deal with disinformation and hate speech on platforms? How do we pursue a regulatory system such as that envisioned in the Digital Services Act, or do we pursue a regulatory system that, as in the US, that is a laid-back approach which was reiterated recently by the Supreme Court to insulate platforms from publishing liability? How do we define and regulate artificial intelligence? Do we adopt our own Artificial Intelligence Act, for example, or do we write a Bill of Rights for artificial intelligence and leave the rest to fate? How can we end the growing tendency to resort to digital mercenaries such as Team Hohe, Cambridge Analytica, and many more? Despite multiple judgments from domestic and regional courts, how do we ensure that state parties to the African Charter desist from shutting down the internet, especially during elections time? These are some of the issues for which you have all been invited for these 3 days to share your expertise. As the special mechanism, we have made multiple strides to ensure the modernization of the mandate and to enhance its capacity to answer some of these questions. The adoption of a Declaration of Principles in 2019 was one of the major steps to address digital rights issues, following the mention of electronic media in Resolution 54 of 2001. The declaration built upon its 2002 version, as well as Resolution 362 of 2016, which first mentioned freedom of information and expression on the Internet. Today, we try our best to offer guidance on various issues such as data protection, artificial intelligence, platform governance, Internet regulation, and so forth. Presently, we are making use of our protective mandate to address information and communications rights violations through diplomatic channels as provided for in the standard operating procedures for special mechanisms. As such, in the last 2 years, we have written to the governments of Ethiopia, Zambia, Uganda, Egypt, Botswana, and many more others to address allegations of internet shutdowns, problematic artificial intelligence deployment, digital censorship, and the surveillance of journalists and human rights defenders. We are also heavily utilizing the periodic reporting procedure to bring to light and solicit government feedback on similar issues. At the 73rd Ordinary Session of the African Commission held in Banjul in October 2022, we pressed hard on the governments of Mauritania and Côte d'Ivoire to speak to allegations of information and communications rights violations and to report on the measures taken to prevent same. At the recently held 75th Public Ordinary Session, held in Banjul this month, we also solicited the governments of Zambia and Senegal to provide feedback on allegations using Pegasus and circles. We also addressed allegations of Huawei assisting the government of Zambia with decryption services in order to uncover the identities of a group of anonymous online bloggers. Our methods might not be perfect, but our resources are very limited, but we are doing the very best we can to address the platform information and communication rights as a continental priority. My expectations from this regional conference as Special Rapporteur and as member of the African Commission are vast. Firstly, I wish to have this opportunity to once again meet you in person. The chance to meet with the hardworking and dedicated stakeholders in the digital rights sphere seldom presents itself, and as a community, it is vital that we meet regularly in person to connect. Secondly, I am keen to hear what you would specifically like the special mechanism and the Commission as a whole to do and to do differently to protect and promote information and communication rights in Africa. I also want to walk away with binding commitments on how we can collaborate as technical partners to address the issues that will be discussed here during the next 3 days. This regional seminar itself is the outcome of discussions and commitment that happened between the hosts at a similar convening. Therefore, we know for a fact that cooperation is vital in our sphere. Information and communication rights are not only fundamental to the achievement of all other rights, both civil and socio-economic, but also essential to achievement of common continental and developmental goals. To the Honourable Minister, I want to reiterate the AU theme of the year, which is to achieve the implementation of the ACHPR. May I quote from the Honourable Minister of Justice and Attorney General of the Republic of Gambia, who at our 75th Ordinary Session stated that respect and protection of human rights is a vehicle towards achievements of a goal for the ACHPR, which in turn will improve African livelihoods. Here in Namibia, freedom of expression and access to information has played a huge role in the country's development. It is journalism that corruption has been unearthed in one of the world's largest economic contributors. It is the selflessness of journalists and human rights activists that continue to uncover systems of coloniality and advocate for redress for victims of a genocide. It is through digital activism that the LGBT people of Namibia have fought for their rights to exist, culminating in the recognition by the Supreme Court. I therefore want to applaud the government of the Republic of Namibia for understanding the value of information and communications rights through the very existence of a ministry dedicated to these global priorities. As the Special Rapporteur, I cannot take the floor without utilizing this special opportunity to do a bit of advocacy. The Republic of Namibia is without a doubt an example of African democracy, known for its peace, diverse population, rich history, and beautiful geography. In addition to all these, Namibia may also claim its position as a champion of human and people's rights, and specifically information and communications rights. Already, the State Party is being celebrated for having a vibrant Ministry of ICTs, with one of the youngest deputy ministers ever appointed on the continent. In addition, the Namibian mission in Addis Ababa is an exemplary mission that continues to engage with the African Commission and directly cooperates to ensure the protection and promotion of human and people's rights. I, as Special Rapporteur, wish to work with the Republic of Namibia to build upon all these existing gains to make the Republic of Namibia an example for all other African state parties. I wish to therefore take advantage of this opportunity to invite the Republic of Namibia to participate in our next public ordinary session. In addition, I also wish to invite the government through the Ministry of Justice to ensure that it submits its periodic report. I also want to request the Minister to ensure that when the periodic report is prepared, there is an informative and robust section on the implementation of Article 9 of the Charter, which also includes an explanation on measures taken to implement the government's obligations as regards information and communications rights. Finally, Honourable Minister, ladies and gentlemen, let me thank you for this opportunity to speak to you on these issues. I cannot express enough my excitement and optimism for this and many other future engagements. May I wish you all a wonderful regional conference, and I hope we will find the opportunity to also explore the beauty and hospitality of the Namibian government and Namibia as a whole. Thank you for your attention.
There you have it, Commissioner Topsy Nona, of course, a special rapporteur. I think, Namibia has a lot to offer, Commissioner. I'm sure you've heard this before, and we certainly hope that you do find the time to visit and experience what Namibia has to offer. Thank you so much once again, and it's good to hear that, we do have the backing of the ACHPR, and of course, we hope that this relationship does continue to grow, and that you are, of course, a champion for information and communication rights on the continent. Once more, please. Now, our next speaker, I do not even know where to begin. He is, of course, currently the Minister for Information and Communications Technology here in the land of the brave, but he's held former positions as Minister of Urban and Rural Development. He was also the former Minister, or Deputy Minister, pardon me, for International Relations or Foreign Affairs at that point in time. He's been dubbed as Namibia's most avid scholar, and rightly so. Dr. Peya Moshelenga holds 12 academic qualifications from 6 institutions, higher institutions. And of course, this morning he joins us to deliver the keynote address. Ladies and gentlemen, please put your hands together and please rise for Dr. Peya Moshelenga, Minister for Information and Communications Technology.
Thank you very much. Please be seated. ceremonies, Ms. Freya Grenhagen, the FES resident representative in Namibia, and the Fesmedia Africa director, the Honorable Topsy Sono, the Special Rapporteur from the Africa Commission on Human and People's Rights, my dear brother Jafar Musa El Kadum, the UNESCO representative in Namibia, the Honorable Nema Lugangira, Member of Parliament from the United Republic of Tanzania, our distinguished Ombudsman, Basilius Jakuka, the Executive Director of MICT, Dr. Audrey Mate, Ms. Zutaitis, the Director of Namibian Media Trust, distinguished delegates, members of the media, ladies and gentlemen. It is my greatest honor and pleasure to address you today at the official opening of the Fesmedia Africa Regional Conference on Information and Communication Rights in Africa. Namibia is honored to host this important conference just 2 years after hosting the UNESCO Global Conference and World Press Freedom Day 2021 celebrations under the theme Information as a Public Good. This occasion cements Namibia's position as a beacon of press freedom and human rights in Africa and the world at large. I am confident that the experts gathered here for this conference will come up with implementable recommendations and a roadmap for the promotion of information and communication rights in Africa that will be adopted by all stakeholders, including the African Union and its organs, governments, and civil society actors. We are gathered here today to have a dialogue and deliberate on information and communication rights in Africa, a subject that has become increasingly critical due to advancement of digital and information and communication technologies. Communication rights is universal as it is embodied in the Universal Declaration of Human Rights. The African Declaration on Internet Rights and Freedoms recognizes that a fundamental challenge in need of urgent resolution in the digital age is how to protect human rights and freedoms on the internet. This conference, anchored on the themes of digital rights, access to information and human rights, is a platform that brings together all of us who are committed to promoting these fundamental rights for Africa's citizens. I would like to particularly implore upon stakeholders on communication rights to start focusing on communication rights for people with disabilities. So that they could be brought in the mainstream of information and communication. Director of Ceremonies. Africa is guided by the African Charter on Human and People's Rights, which provides that every individual shall have the right to receive information and that every individual shall have the right to express and disseminate his opinions within the law. Article 1 of the African Charter obliges state parties to adopt legislative or other measures to give effect to the rights, duties, and freedoms enshrined therein, including rights related to information and communication. Aligned with this and recognizing the impact of the internet and technology, the African Declaration on Internet Rights and Freedoms, which seeks to promote human rights standards and principles of openness in internet policy formulation and implementation on the continent, provides another framework to strengthen these rights on the continent. The African Commission on Human and People's Rights Declaration of Principles on Freedom of Expression and Access to Information in Africa declares that freedom of expression and access to information are fundamental rights protected under the African Charter and other international human rights laws and standards. The respect, protection, and fulfillment of these rights is crucial and indispensable for the free development of the human person, the creation and nurturing of democratic societies, and for enabling the exercise of other rights. In addition, the model law on access to information for Africa by the African Commission on Human and People's Rights recognizes that lack of access to information deprives citizens of their right to participate in the decision-making process and hold elected representatives accountable for their acts or omissions, and creates an environment in which corruption, maladministration, and mismanagement of national resources may thrive. By and large, these conditions exist throughout Africa, making the adoption of access to information legislation a common approach to a common problem. Director of Ceremonies, the Republic of Namibia, as part of the international community and as a member state of the African Union, is committed to protecting and promoting information and communication rights by way of adopting and implementing robust and progressive laws and policies. Our government firmly believes that digital rights, access to information, and freedom of expression, and the press are inalienable human rights that must be defended at all costs. The Namibian Constitution, which is the supreme law of the land, protects these rights and, as a society, governed by laws. Namibia citizens are guaranteed their information and communication rights. Namibia is known for its outstanding record when it comes to promoting press freedom and freedom of expression and access to information. As we are all aware, Windhoek is the birthplace of the Windhoek Declaration for the development of a free, independent, and pluralistic press, adopted in 1991 at the UNESCO seminar on promoting an independent and pluralistic African press, which led to the adoption and annual celebration of World Press Freedom Day on 3rd May, and the Windhoek Plus 30 Declaration, which declared information a public good and further impel the principles and spirit of the 1991 Declaration. Parliament of the Republic of Namibia passed the Access to Information Act in the year 2022. This momentous development demonstrates the commitment of the government to promote access to information as a human right that must be enjoyed by every Namibian. Namibia joined other 25 African countries that have adopted access to information laws, and steps towards implementing this law were immediately taken in line with the EU model law that stresses that properly implemented access to information legislation hold the purpose or hold the promise of fostering good governance by improving information management and by enhancing transparency, accountability, and greater participation of the populace in public affairs. The international community has over the years commended Namibia for her commitment to the promotion of information and communication rights. The efforts by the government has received recognition at different international and regional fora. Namibia was recently rated as the country with the freest press on the African continent by the RSF in its 2022 World Press Freedom Index. This is another testimony to the commitment by our government to advancing press freedom and promoting information and communication rights. I would like to congratulate Fesmedia Africa and the Friedrich Ebert Stiftung in Namibia. Their co-host, Commissioner Topsisono, the Special Rapporteur on Freedom of Expression and Access to Information in Africa, in the Africa Commission on Human and People's Rights, as well as their partners, UNESCO Windhoek Office and the Namibian Media Trust, for hosting this important conference. I wish to thank our hosts and partners on behalf of my ministry and Namibian government for choosing the land of brave as the country to host this conference. I wish you all the best in your deliberations, and I thank you.
Minister for Information and Communications Technology, Honorable Dr. Peya Mushelenga. Of course, that sort of brings the official part of our program to a close. We now officially begin with our activities, very important activities, and I'd like to welcome to the fore, that's Mr. Maxwell Kadiri, who would of course be providing a landscape of the overall conference themes and just what we can expect over the next 2.5 days. Thank you so much for being here once more, and of course we look forward to an exciting and of course fun-filled but also a very educative regional conference. Mr. Maxwell Kadiri.
Good morning, Honorable Minister, the Special Rapporteur, the MP from Tanzania, the UNESCO resident rep, the Fesmedia resident rep, and permit me to use the expression also I've heard used here, but used a lot in my country, all other protocols observed. I know we are in short supply for time, so I would immediately move into trying to address what is supposed to be my responsibility at this open plenary session. Let me begin by thanking the organizers for extending an invitation to me to attend this august occasion, and also for giving me the unique responsibility to speak from a landscaping perspective. This is my first ever visit to Namibia, despite the fact that I've been in Southern Africa for quite a bit over the last 2 decades or more. So it's quite special, and I'm hoping that had been expressed by 1 or 2 of the speakers. We'll get to see what Windhoek, has to offer. And I would take Zoe. I would take Zoe to task on that, in the context of all that she said and much more. Given the fact that we've heard quite a bit, just in terms of, from the Special Rapporteur, in terms of the lay of the land on the issues at stake here, which is ATI, FOE, and digital rights more broadly. And then we've also heard what the plans and proposals from Fesmedia Africa is in terms of the thinking behind this convening, as well as heard the very good news and perspectives from the Honorable Minister, including the enactment of an ATI law by Namibia in November 2022, assented to by the President, I think 28 December 2022, although it would be useful to hear what steps are being taken to operationalize that legislation, given what I also had noted from a small bird, that even though your whistleblowing law had been gazetted 6 years ago, but operationalizing that legislation is still in the works and yet to be experienced. So I'm hoping that one of the outcomes of this conference and having the Honorable Minister here with us will be a clear sense of a roadmap on how that legislation would be immediately, operationalization would start almost immediately, but which will be roughly 6 months after it was gazetted, since that happened in December. But I'm also quite conscious of the fact that the organizers have said, as part of the objectives of this conference, to look at issues around challenges militating against the effective utilization of the laws, of the rights that we are focusing on here, but also looking at what practical steps can be taken to advance these rights from the perspective of implementation. There's a colleague of ours from UNESCO who's on standby and would also be inputting when I'm done, and I would invite him to also present his perspective, given UNESCO's significant investments on these issues on the continent over the period which my friend and brother had also spoken to. But I would also urge that this is also unique for many of us, because I see many compatriots who've been in the trenches with us on the continent for the last 2+ decades, fighting for the entrenchment and advancement of these rights on the continent. I'm not saying that to hint that people are old, but just to say how long the battle has been, for these many years. So permit me to say what I've set as in line with the objectives that Fesmedia Africa has put, what I've set as my overarching framework for this conversation, because it's a conversation, is that it enables us step back, particularly many of us who have been in the trenches, because I see my good friend Mukelani here, I see Henry Minor, of course Zoe has been a thought partner in the advocacy, my boss from inception, Edet Ujo, and many others in the room who have been in this battle for quite a while. And in bilaterals we were having yesterday, we were like, maybe it's time to step back, reflect and find out. A lot has happened, as the Special Rapporteur has outlined. So many soft law initiatives have been advanced and adopted from her predecessors up until her time. So we are not where we were in the 90s, where there was no access to information legislation in place in any part of the continent. We are not where we were in 2000, where the Special Rapporteur at the level of the African Commission was just a Special Rapporteur on freedom of expression. That was Commissioner Andrew Chigovera from Zimbabwe. We are not where we were, where due to the advocacy of Commissioner Pansit Lakula, who currently sits as chair of the Information Regulator of South Africa, the mandate of the Special Rapporteur in 2006, 2007 was expanded at the African Commission session held in Congo, Brazzaville, to also deal with the issue of the right of access to information. We are also not where we were, where, again, due to her consistent advocacy and the support of many of you in this room, she led the charge to develop the model law on access to information in Africa, which incidentally, as Mukelani and Mr. Ojo will speak to, was in response to a challenge issued by the government of Ethiopia on the margins of an Africa convening on access to information in Accra under the auspices of late President Atta Mills, as you would recall, where he threw back the challenge to the Special Rapporteur at the time that you guys are hounding us to promote access to information as a right and by enacting legislation. But we don't see an Africa model, and we don't want to ape the West. So help us to help you. And that challenge, taking that challenge up, was what resulted in what became the model law on access to information in Africa, and which model law, I dare say, with every sense of humility, remains about the most progressive piece of model law on ATI globally. And in the context of that conversation, incidentally, at the time that activity was being pushed by various stakeholders, the Organization of American States, OAS, was also pushing its own process for developing a model law. And when you compare, with every sense of humility, when you compare both documents, I know that there was a process for updating that model. I'm not sure where that is presently. Where you compare both documents, you will see that the model from Africa is heads and shoulders above what the OAS did, and was also so much more ambitious, because while the OAS process, which some of us participated in remotely, was mostly amongst civil society, in the context of the model law, it was a broad-based conversation that included state parties who are state parties signed up on the African Charter, a diversity of public institutions and stakeholders, including security sector operatives, in discussing this vexed issue, as well as corporate entities, just to ensure that whatever model Africa developed responds to the challenges on the continent and advances the conversation. It's also fitting to say that it was in the context realizing the challenges of elections, and how it makes or mar Africa development. And my country has just come out of a very contentious election, and our inauguration happened barely a few days ago. In fact, part of why I missed the inauguration was I was airborne here, so you can imagine the sacrifices we made to make that, and I also assume Mr. Ojo feels that way, was also looking at how you build the nexus between deploying, because we talk about access to information as a tool for realizing several other rights, whether civil and political, economic, or social. But elections, given its contestation and its impact, on development, and what the African experience has been peculiarly, was also informed why the Special Rapporteur at the time also advanced the development of a set of guidelines on ATI and elections. Of course, we can speak to, the jury is still out on how effective that has been put to use, but I'm aware that certain groups, including University of Pretoria, and I believe AFIC as well, has also deployed that soft law instrument to just track how process, deploy ATI as a norm for advancing transparent, credible, and free and fair elections on the continent. Of course, there is also the default gap, which I also would promptly point out, that at the time at which that process was ongoing, the deepening of the use of technology in our lives was not what it was or what it is now. So you could say, there is possibility for expanding that, given how we've now pivoted into deploying technology, in conducting elections. At least, again, the contentions in my country's recent general elections also speaks to the challenges with deploying technology, particularly the BVAS, which is the bimodal voter voter accreditation system, as well as the portal on which there was supposed to be real-time transmission of election results from the polling booths, telling you how technology has become part and parcel of our lives, including how we conduct elections. I would then pivot, and this is where I would leave that, just looking at the soft law framework and hard law framework, and then go into what are the challenges and what practical steps can we begin to consider to take things forward, and also to signpost areas where Fesmedia, may also be interested in committing investments. Let me also say very quickly, I speak here as Kadiri Maxwell, a son of Africa, a Nigerian and a legal practitioner, not speaking for the Open Society Foundation, so that we don't mix those up, and we are clear. We are quite clear, because I work for the Open Society Justice Initiative, but there's the Open Society Africa, which has a pan-continental program now, which many of you are familiar with. So I can't make commitment in that regard, but I can advance some of the ideas that we'll consider going forward. The last that I would want to look at, which is pivotal to this conversation, is the Declaration of Principles, on freedom of expression and access to information. Whether you're talking of free expression, press freedom, broadcasting, access to information, and then more particularly, because, again, the Charter is what it is. If you look at the Charter, and I say this advisedly, knowing that Commissioner and her team are here, in the context of the Charter, one of the things that those who were in the vanguard when the Charter was being crafted, the likes of Ibrahim Akan, Chidi, Anselmo Di Carlo, the late Alpha Fala, and the lot, some of the insights they shared from their time in that struggle was one of the trade-offs on the Charter was the issue of the right to privacy. So when you look at the African Charter, there is no specific provision on the right to privacy. And in the context of digital rights, that is, as we know, as many have said in the initial comments here today, is critical, to creating that balance. But creatively, which is why the declaration for me is absolutely important, particularly Part 4 of the declaration. Because when you look at Part 4 of the declaration, it gives effect to what we speak about when you say access to information is a leverage right that ensures the realization of several other rights. Because what Part 4 of the declaration does is using the lens of access to information and freedom of expression to deal with many of the digital rights issues that we experience on the continent and beyond, and also fill that gap that exists in the language of the Charter in the context of the right to privacy. But what, for me, remains a challenge, and this is what I shared with some of the colleagues who had bilaterals yesterday, is let's, as advocates and activists, ask the question, how much have we done to unpack the provisions of the Charter? How much have we done to break not just the Charter, but more importantly, and this is where I would emphasize, the provisions of the Declaration of Principles of 2019, particularly Part 4 of that declaration. And again, in this context, I want to very humbly challenge the Special Rapporteur that some of the insights that colleagues had shared, and which I also buy into, is the fact that I think the time has come in the context of engaging with states, whether it's in the state party reports or in the advocacy missions, because again, that was something that was creatively deployed by Commissioner Pansit Lakula beyond just your normal state party visits, to basically, in partnership with colleagues in this room and colleagues who are outside this room, because I see that this room is missing representation from the North Africa region and from the Central Africa region, which are major parts of the continent where these issues are felt on an ongoing basis. In Tunisia, for example, as I speak, a cybercrime legislation was adopted a few months ago, and that legislation is currently being deployed actively to muzzle civic space and expression, including digital rights. And with all sense of responsibility, to the Tunisian government, things are taken a notch higher, where even the military deploys that piece of legislation to haul civilian suspects before military courts for violating the provisions of that legislation. What more can be more egregious? And that's the context, just as an example, that I encourage Madam Special Rapporteur to, in concert with groups in this room, develop a template through which we review engagement with states, and that template should speak to the provisions of the Declaration of Principles. Because what the Declaration of Principles does is to give life to the provisions of Article 9 of the African Charter. But with all sense of humility and responsibility, the truth, if we must be frank, is we haven't put that declaration to effective use. And that, for me, will be one first takeaway that we must agree. And I'm hoping, and apologies for putting the Honorable Minister on the spot, that given all the wonderful things that Namibia has done in the context of promoting press freedom and free expression on the continent, that Namibia, as a state party to the African Charter, will be a thought partner with the Special Rapporteur to lead this charge, to ensure that the process of reporting on Article 9 takes into cognizance, not in summary form, but in detail, in terms of what steps state parties are taking to comply with the provisions of the declaration. And that my colleagues in this room from civil society would also take on that responsibility to avail themselves to be thought partners in that process. But more importantly, to disseminate information about the declaration in many respects. And what that does is it takes the conversation even beyond states, because when you look at parts of the provisions of Part 4 of the declaration, it also speaks to issues pertaining to the role of private sector entities, which Zoe also referenced, particularly the huge tech platforms and what they do and do not do. And in this context, I would also want to put on the table the different standards that are applied between the global north and the global south in the context of technology and how technology affects us on the continent. The second point I would also want to just pivot into is in the particular context of access to information. In South of General Sani Abacha, it was considered, it was suicidal to be embarking on that struggle at that time, given the risk associated with pushing for that kind of legislation under what we then called a maximum ruler. So yes, Nigeria started that process even before South Africa did, but South Africa bettered the tape before Nigeria did. And it took us another, roughly, correct me if I'm wrong, sir, was it 17 years to get to the point where we had an access to information law in 2011. Reading the background documents for this conference, there was the point made that we do have 26 legislations in place now, which is still less than 50% of the AU member states. Because if you take out, correct me if I'm wrong, Madam Commissioner, I'm not sure Morocco has still assented to the Charter. So if you have 55 AU member states, effectively you have 54 ratification of the African Charter in terms of AU member states. So 26 is less than 50%. So we still have a lot of work to do in the context of adoption. But let's now come to the point of implementation. You have 48% of AU member states haven't adopted ATI laws. Where are we in the context of implementation? And the point I make here is implementation does not necessarily entail looking for basically creating new normative standards or soft law instrument for that process, because what we have, which has been referenced in all the conversations here this morning, in my own humble view, is sufficient for us to push the boundaries on implementation. What is missing, and which is what I'm hoping would also do while here, is in that stepping back and stock taking, ask ourselves frankly, what can we do creatively to advance the process of implementing access to information? And in that creative thought process, let's also be humble enough to even welcome the participation of others who are not in this room, but who also have creative ideas that can advance that and broaden the partnership. Because in some of our earlier conversations, we were also accused of just being the ATI purist, those who lead the charge. But I've been in context where in discussing possible litigation, lawyers are thinking about how do we deploy access to information. But they lack the benefit of the experience of partners in this room because that conversation is not happening. Can we begin to look at that conversation? And a case in point in that regard, as some of the litigation that I'm aware are ongoing in Henry's home country, Kenya, that implicates ATI actively, even in the context of Huduma number. If I pronounce it correctly, Henry, pardon me if I make any mistakes. Speaking to the need for a diversity of expertise, a diversity of experience and views in how we advance the conversation. Now, coming down concretely as I begin to wrap up, in the context of access to information, record keeping remains a challenge. Record organization, record maintenance remain a challenge. And some of the expressions we used to use in the heydays of the struggle was, what do you disclose when the records are not there? Now, can we, and interestingly, and this is one of the areas where I thought we dropped the ball, as I was sharing with Mr. Ojo and a few other colleagues yesterday, if many of you in the room were there, if you will recall, when we started the conversation on developing the guidelines on ATI and elections, in that room at that time, we had the Auditor General of South Africa present in the room, and they floated a key idea that audit process looks at just income and expenditure and auditing how the money has been spent. What for them was missing, and which was a key entry point that they thought ATI would avail, is the issue of record keeping to substantiate the expenditure. And there was a proposal by the Auditor General of South Africa to push for an adoption of a conversation or a framing that makes record keeping, that makes audit process, not only looking at the numbers, but the documentation. And what that does for the ATI process, it ensures that record keeping now becomes a core responsibility of all public institutions across board and further validates what the ATI seeks to do. So that would cure a major lacuna. But we can also optimize that, and this is where technology becomes useful. Digitization of records. You know, in ways, I'm not in any way suggesting that the hard copy records be destroyed, but using digital processes to ensure that those records are preserved for posterity and can be accessed. And taking steps further, in the ATI conversation, because governments, and with all due respect to the Honorable Minister present with us, governments have by default interpreted access to information as the responsibility of the applicant to make the request, and de-emphasized proactive disclosure as the responsibility of public institutions to advance the right. What we've had in many respects is even proactive disclosure not taking effect, and then the obligation being put on applicants, on ordinary citizens, to make requests for information that ordinarily should be proactively disclosed by public institutions. In the experience of, in the aftermath of COVID, which builds on the experience of Ebola, can we, again, hoping that Namibia would lead the charge, reverse that conversation to where it ought to be, which is what the model law proposes, that proactive disclosure needs to be the main framing for access to information, where public institutions are under an obligation to proactively disclose information. And the only information that applicants will be required to request are information that don't fall within the rubric of information that is proactively disclosed. Again, when the model law was being developed, technology was not available. But now we know technology can be deployed to enhance proactive disclosure. When I was coming in yesterday at the airport in South Africa, as I put on my phone at OR Tambo, I got a message basically saying sign up on an app that would let me know if I've come within close contact of somebody who has COVID-19. It's a clear example of how you deploy technology for proactive disclosure for public health. But can we mainstream that across board in terms of how ATI is advanced? That's something I think we should think about more closely, and something that we need to advocate, and how technology helps to advance proactive disclosure. And there are so many other concrete proposals that I wanted to make, but time is not on my side, and I'm hoping that there will be time to also advance those. But where I would end is, can we, advancing the spirit of the model law, And as the Nigerian legislation proposes, can we make failure to proactive disclosure punishable and actionable in court? And is that something that Namibia wants to lead on? Is that something that needs to be referenced in the template the Special Rapporteur should develop? Because what that then does, it forces information holders to take proactive disclosure seriously. And what that does to not just free expression, not just ATI, but even in the context of digital rights would be absolutely amazing. Last but not the least, we have now a global set of standards on ATI and national security. Because at the time at which many of us were in the trenches pushing the charge on ATI, national security was the biggest elephant in the room that froze the conversation in terms of a partnership between state parties and ATI activists. In the context of digital rights, where privacy has become one of the serious considerations in the context of rights, can we also think through developing a set of guidelines, standards, in the context of balancing ATI and privacy? That was something, again, that fell off the radar. That was a priority for previous special rapporteurs, but that fell off the radar along the line. So I would stop here and invite Marius, who's online, to kindly join, and hopefully, with the benefit of time during the quick Q&A, come back to a few other proposals in terms of concrete recommendations that we should consider in the context of this conversation. Thank you very much. So, Marius, the floor is yours. Is he online now, Mr. Moderator? Okay, yes, so he's online. I'll take my seat while he continues. Thanks.
All right, thank you very much, Mr. Kadiri, for that very comprehensive overview and some very key questions as well during that presentation. Of course, we're just waiting for Mr. Marius Lucosianas to join us. He's at the UNESCO headquarters in Paris, France, and he'll be joining us in a very short bit. Marius, are you there?
Can you unmute me? Oh, okay.
Apologies for that.
And also the camera.
Yes, we're quickly sorting that out here. Good morning, Marius.
Okay,
how are you doing this morning? How's Paris?
Good morning. Warm welcome from Paris. I hear you well, and I'm ready to start.
Fantastic. Marius, just quickly check your settings there. Can you please prompt your camera here?
I cannot, because it says that the host has to do it.
Yeah. Fantastic. We see you now. Good morning, Marius.
Good morning, and let me start with a quick additions I have to a previous speaker who made an excellent overview. So basically, a few points to add. First, looking into the big picture, we see that access to information laws have two peaks. Let's say from 1766 to 1990, only 14 countries had access to information laws. And then the first peak where the number of laws had doubled was somewhere around 1991. And definitely that was connected to a general democratization of political systems in the world. And then the second peak started around 2001. And that's basically where I'd say the UN had its first Millennium Development Goals framework. And then, of course, later on, Sustainable Development Framework, which I will talk about a bit later, added to that. And we had, since 2001, plus 86 laws, which is like 2 or 3 times more than the previous number. since 1766, as I've said. What do we see here, and why this second peak happened, I think, and why the first peak happened? I think the first peak was very much connected to the issue of human rights. The second peak, of course, also was connected to human rights, but also it was related to the fact that on the global level, everybody realized that access to information is part of the development agenda. So here we are, I think, from the global perspective, I think we have two major points, major driving forces behind access to information laws. Now, looking globally from the UNESCO perspective, Director Musa had mentioned already UNESCO survey of SDG 1610.2. And this is our main source of information when we make all different kind of conclusions on trends in the field. Last year we had 123 countries which responded to our survey. So the survey is basically focusing on adoption of access to information laws and implementation. And if we look into Africa and to the numbers of 2022, we can see that 29 countries had responded to the survey. So we have ample of statistical data on Africa. We can also see, comparing to the other regions, according to the UN classification, that there are two regions which have a considerable number of countries which don't have laws, and that is Africa and then also the Pacific region. Even though Africa is improving greatly, but I think that comparing to Latin America or other regions, we still have quite a bit of, I think like 13 countries which don't have laws. And then there are some countries which have drafts which are sitting in the parliament, but they have to be adopted. And here Namibia showed an excellent example in the end of 22. Now, a few more, I will touch on a few aspects because I have only 10 minutes, so it's impossible to cover everything. So talking about the legislation, I will focus on the weakest point of the legislation, ATI legislation, in my view. In 2020, we had made a survey, an analysis of the laws of 127 countries, and we found out that only 37 of them explicitly refer to persons with disabilities and their rights to varying degrees. The common themes in these legislations relate to placing a request for access to information, forms in which access is provided, conditions for delivery of accessible formats, provision of further assistance, and so on and so forth. We, of course, also identified 8 shortfalls of national provisions of ATI and disability issues. They are online. I am not going to go through them, but they are also telling. In general, talking about this aspect, first and foremost, it is evident that the rights of persons with disabilities are absent from most ATI legislations. My previous colleague here was talking about national security, and that there are instruments to understand how the interplay between access to information and national security as the one of the key reasons for exemptions, and also about the privacy, which but I would add to that also the issue of the rights of persons with disabilities within the ATI legislation. Now, going back very quickly to our survey. Our survey allows not only to monitor, of course, but also to make certain conclusions and to observe certain trends. And what we are observing in general, I'm not going to go into the details, but I have to say that we are observing one of the interesting trends that countries with specialized oversight bodies perform better. We know that implementation, there are different implementation mechanisms in some countries. Implementation goes through the courts, in other countries through oversight bodies, and so on and so forth. So here we definitely, we can say that we observe that trend since 2019, monitoring the implementation of access to information laws. I will also concur very much with the previous speaker regarding record keeping. I think it is important. In addition, I would say that the third important aspect is importance of regional networks. And here, as you may know, we are supporting African Network of Information Commissioners, and next week we are meeting in Kenya, and hopefully will advance on many of the capacity and otherwise related issues. So these are, and then one more aspect which I wanted to highlight is the digitalization of information request procedure. And that we don't have a data yet. We have focused on that aspect in our 2023 survey. We are collecting data, how many ATI's implementation systems have the specialized ICT platforms which allow to file the information request and to see how it goes from one stage to another until it is either rejected or accepted and the response is given. The two platforms which we have noticed have a very good support to access to information are Mexicans as well as Canadians. But as I've said, we are collecting this information, and I think that this is another very important point for us to focus how to employ ICT solutions as well as maybe artificial intelligence solutions to strengthen access to information implementation. And a few more very quick points. Raising awareness. UNESCO is doing a lot. We are not only the custodian of 1610.2, we are also organizing all over the world the celebrations of International Day of Universal Access to Information. We've organized since 2017 120 national, regional, and international celebrations. And I'm saying this not just to praise what we do together with the stakeholders, but asking the stakeholders to really see that seriously, because it is a very important platform for raising awareness regarding access to information. So this is the quick additions I wanted to make, and the last one is talking about the EDUI during the International Day of Universal Access to Information of 2022, which we organized in Tashkent. We have adopted a Tashkent Declaration, I mean the meeting of EDUI, on universal access to information. We are planning to table that declaration for the endorsement of the UNESCO General Conference, and that is the declaration which is specifically targeting universal access to information, and we are hoping that it can become a very important reference point for access to information worldwide as a UNESCO endorsed document. Thank you, colleagues, and back to you.
Please give him a round of applause. Thanks so much, Marius. I hope you remain with us as we go into the plenary conversation on the subject matter. and then we'd also take a few insights from you in response to any questions or comments. So if, with the guidance of the moderator, I think we can get into plenary conversation now. Oh, wow. Okay, he says we have 10 minutes instead of 50. All right, so please, the floor is open. Just indicate by show of hands, or I think there are mics, or is there a roving mic that people can use? And I would humbly encourage that, in the spirit of the practical steps that we're identifying, that colleagues emphasize practical steps, that would help the Special Rapporteur and then all the stakeholders and whatever commitment we'll make. Yes, so Edith, please.
Thank you very much, Maxwell. I hope it's working. Now, I think in your presentation, as well as in Marius's, you sort of identified adoption and implementation. And I thought we should break down implementation. Within implementation is enforcement. But I really didn't hear much about mechanisms that we can apply to enforce ATI laws. Could you share some ideas with us? Thank you.
Thank you. My name is Isaac Manar. Thanks for a very insightful overview, Maxwell. That was really good. Following up on some of our discussions yesterday, and specifically your reference to how Part 4 of the Declaration on Internet online rights, how that can be deployed to essentially, I think what you were saying is to bring the application of the model law into the digital age, right? I would love to hear what would be, from yourself, but also from other participants, what would be the right steps to take to actually make sure countries use Part 4 of the Declaration to implement their access to information legislation. I think the guidelines on ATI and elections may be a really good way in which ATI principles were applied to election periods. And maybe it's time that we look then at guidelines on how Part 4 of the Declaration can actually assist us in deploying the principles, and particularly the proactive online disclosure of information of the model law in country legislation. Thank you.
All right, do we have any other contributions?
There was a hand here.
All right, we'll take a lady quickly, and then we'll go to the gentleman over there.
Good morning, everyone. My name is Lydia Gachungi, working with UNESCO Region Office to the African Union. From where I sit, I did hear you talk so much about access to information, a proactive action that needs to be punishable and actionable, and you said proactive disclosure if it's not there. But again, you also alluded to the fact that digitization is key. And when you look at the recommendations that we are talking about in this room from the concept note, if there is one thing that I would call on partners to put more effort in that I've not seen, and this is what also African Union, I do believe they are pushing for when it comes to making accessible the information that is of cultural heritage from Africa perspective and many other, not just public information held by the government and any other partner, but also our cultural heritage on the continent that is so key even to the generations to come. If there is a place where I would recommend very strongly that partners put their resources is on digitization. We have very little that is coming through from partners, yet we keep hearing this conversation in every room. Thank you very much.
Thank you very much. Maxwell, congratulations again. And I see that you are getting deeper and deeper into the issues, and I'm very happy. But I now speak, I have started with Maxwell and the rest on ATI issues, but I'm a regulator, media regulator now. And my epiphany is that we've come to a point where perhaps we need to reset. When we as activists and advocates speak, we need to begin to realize that advocacy is a coded admission that the power of action lies with somebody else that we seek to persuade to adopt our point of view and to act in a way for the public good. But we tend to completely ignore the reality that the only reason why we have all the struggle for all this period is because governments have legitimate fears. And we tend to think of that as if it is only because governments inherently do not want to be transparent, and the governments are corrupt, and governments are autocratic. And as a result, we set this binary life. It appears to me that in our whole reflection on ATI issues, the only time we tend to recognize the legitimacy of the state in terms of its fears is in that small corner of creating exemptions. I have come to the conclusion that perhaps the way to advance the conversation is to admit the broad questions that you raise, questions about free expression, access to information, and media regulation. Because it is the legitimate fears of the state that lead to the pushback that we see. Unless we are able to put all these issues directly on the same table for reflections, where together we can define a framework that enables us to understand exactly what the fears are that the states are seeking to protect, and what are the legitimate ways to address that. Otherwise, my fear is that we are going to have these conversations in silos and in cycles, and then we are going to frustrate ourselves. Thank you very much.
Thanks a lot, George. Yes, please.
Ms. Masters?
Hi, Rehana Masters. Thank you very much. I think you kind of started sparking our creative process by, urging us to look at practical solutions. I agree with you about the revised declaration, and you referred to Section 4. Obviously, you've given it much thought. So I was just wondering, how do you see us unpacking it? Because I do think we do not use the contents of the revised declaration to underpin our work. And then while I hear Lydia, and I agree very much so about the digitization, when you do address it, let's talk about, it then does widen the gap. We're kind of being left behind as Africa in the digitization process, especially around, state institutions. But then how do we then decrease the gap in terms of people, accessing that kind of, process? Thank you.
Yes, I think.
Thank you. Thank you very much. Just to allay your fears with regards to the implementation in Namibia, where we are now is that the minister is considering the guidelines, which will then be rolled out for consultation with the rest of the country. So we'll be getting there very soon. That's with respect to ATI. So guidelines are being worked on as we speak. Now, you mentioned something about, before I get to the second point, which is that I think this kind of accommodations need to include governments. I think just to pick up where my brother left, he said you can't have these accommodations on your own, then come back to us, you must do this, after you've been left out of the accommodations. I don't see how many governments are present here. I know there's Tanzania, there's Namibia, I don't know who else is from government. But I think generally we want to have a dialogue where all of us on this process, and implementation becomes easy that way. So there's no misunderstanding as regards to what ought to be done at what point. So the attitude of civil society generally is that they have accommodations on the sides. Then at the end of the day, then they come back and say governments are not doing this. Those are conversations, then you must own them. But if you're going to include us, let us own all of these processes. We agree where we disagree. Then we have a blueprint that all of us can own going forward. And this feeds into the next point, which speaks to proactive disclosure. What do you proactively disclose? See, I think that is an important point. We must not even think about criminalizing that, but what do you think I should be disclosing? I think the one who has a need must express it. Then the obligation now is essentially for those that have information to disclose it. I do not know what the rest of ATI looks in the continent, but the import in Namibian legislation is that this information is not just with government. I see there's a bit of emphasis on government. In our case, ATI applies to private business as well. So don't be under the impression that this is only affect government. Essentially, private sector, they're also affected. Any organized institution is affected by that. So what applies to government here will essentially apply to the private sector as well. I'm going to excuse myself after the spoken director of ceremonies. So I just want to make the last point, which is that I think the issue of digitization, access to information, communication rights, they need to be put into context as well. To what extent do our countries have rolled out infrastructure that even if you are seated in the most remote part of the country, you can actually have access to information and you can actually exercise your right? With regards to, if you're going to digitize, as I understand, and I agree, I think request procedures for ATI ought to be digitalized, ought to be automated in such a manner that it's not a manual process, such that if you are seated in the most rural part of Namibia, then you'll be forced to come to the nearest town to be able to do that. So there's also a responsibility for us as governments to ensure that infrastructure is actually rolled out throughout the country so people have access to information in a true sense. I submit. Thank you.
Maxwell, I know it's a very difficult one, but maybe let me give you 2 minutes just to perhaps give a general response to many of these queries. But we really need to start with these sessions. We're way behind time, so we'll just give Maxwell two minutes to quickly just give perhaps an overview of that.
I'm worried. My sister is looking at me and saying, why not give your 2 minutes to me? So can I negotiate with you that I split what I have with her?
Thank you so much. It's important to hear the voices of women. Thank you, Maxwell, for setting out the scene for the conference. My name is Talda Mawari from Zambia. I just wanted to ask that you add in the setting of the conference themes, perhaps we could consider separately the right to privacy and also data protection, often which are issues that we are finding are in access to information. We are discussing them under access to information, but in most countries they are happening outside of access to information. So the example of Zambia, the Data Protection Act, which is starting to be operationalized, is outside of access to information conversation, but it is in conflict as much as it is also having collaborative issues with access to information. So please write data protection and the right to privacy separately. Thank you.
Thank you. And you saw I was looking across the room at my friend and brother. Now on Dishishi.
One more last contribution.
Yes, I will have to plead with you that we all are I'm suggesting that we all collectively give up 5 minutes of our tea break so that we can wrap up this conversation effectively, because the points that have been raised are so important that we can't just put them under the carpet, please.
Okay. Well, how does the House feel? Supported? Okay. All right.
Thank you very much, Mr. Maxwell. My name is Ismail Okwayami from Nigeria. And because we cannot overemphasize the importance of information to effect positive change in our society, so is also the struggle and advocacy for access to information. So as a young person myself with a very special concern for youth inclusion, I want to suggest that to sustain the struggle or the advocacy for access to information on the continent, we should consider mentorship programs for young people in the struggle, because you agree with me that what the concerns in the 90s was as regards to access to information are not the same as we have today, and what the concern was in the 2000s are not the same as we have today. So as we improve and as technology has emerged, new concerns has actually arose within the access to information struggle. So we should consider to those people, I mean, the the generation before us that has actually contributed to the struggle for the access to information on the continent too. And to see how they can also adopt mentorship of young persons, to see how they can take over from them as they wind up in the activities to ensure that we have more access to information on the continent. Thank you very much.
Thank you so much, Okwayemi. I will start with you and just say that's a challenge to Mr. Ojo, that MRA needs to have a mentorship program in place, you know, to mentor young people in Nigeria. Okay. No, as a process of ensuring seamless transition while remaining in charge. You know, so that's a quick one in response to your point. Now, for my sister from Zambia, these are some of the practical steps I had, but there was no time. Now, the point you flagged is spot on, and the reason why I was looking at Bukelani, and I would also invite Commissioner Topsy Sono into this conversation, is I don't want to use, given what we've gone through in the context of COVID and in the aftermath of COVID and the dysfunctionality of the global order now, I don't want to use the expression best practice, you know. But I would say the evolving practice, which is appearing to be good practice, is to domicile oversight of ATI and privacy and digital rights in the same institution. And that is where the information regulator becomes a good example, you know, for taking the process forward. And the information regulator is the good example for Africa, and it's in the same grouping as, I think that's the same experience, correct me if I'm wrong, in Germany, in Mexico, and in the UK. And the value of that is exactly to deal with the point you raised, where these rights are superintended by the same institution, and they are able to have a convergence of perspective rather than constant animosity. And that's the experience in many other countries where that convergence is not happening. But again, without putting Henry on the spot, I would also welcome him in terms of the conversations we are going to have going forward, because Kenya was also an interesting scenario where the ATI provision of 2016, which we all worked on, provided that whenever Kenya has a data protection legislation, it will be oversighted by the oversight mechanism for ATI. But as you very well know, and Minor can speak better to that than myself, in the politics of governance, the way the ATI law evolved in Kenya was such that the cabinet secretary at the time made it very clear that he wasn't going to allow data protection run rogue and not be under his supervision as ATI did. So inherent in that, and that is something I've challenged my Kenyan colleagues to actually deal with, including through strategic litigation, because what you have in context is a situation where an existing legislation provided for a process. By the time lawmaking was happening, that lawmaking process did not comply with that existing legislation. And that lawmaking process also frustrated Article 10 of the Kenyan Constitution that mainstreams clear principles for governance, which includes transparency, which would have enforced that convergence. So going forward, and this also speaks to the issue of a combination of implementation and then oversight mechanisms. In Africa today, you've got two key networks: the data protection network, oversight mechanisms, and then ENIC, which is being chaired by the South African Information Regulator. Now, even at that, although Madam Chair of the Information Regulator tries to foster a conversation across both networks, but integration of both networks is not happening, which speaks to the challenge. And this is one of the things I had put in my practical steps that I was going to put on the table for Madam Special Rapporteur. One, to be a facilitating framework for integrating the conversation between the data protection mechanisms and the access to information oversight mechanism, and then bringing that within the rubric of the African Charter, because these institutions are essentially advancing the provisions of the Charter. And like I said, even though there's no specific provision on privacy, to the extent that the Declaration of Principles exists, which speaks to the issue of privacy, that's the platform for facilitating that conversation and ensuring more integration. And then hoping that countries that don't yet have data protection legislations or mechanisms would take the example of South Africa to see how to ensure better integration in ways that enhance convergence for the benefits and the protection of both rights, which are now absolutely important. And that would also speak to the issue of the guidelines that Isaac was saying. But like I said, we need to do this thing in small bites, in bite sizes. So that's why, rather than just look, if we had a set of guidelines that speak to creating the balance between privacy and ATI, which advances part 4, then that now also becomes Africa's contribution to the global conversation in terms of ATI and privacy. In the context of what George said, now, if George, if you were listening to me quite closely from my earlier points, I did say the African constituency was bold enough that when the conversation on the model law started, state parties were in the room, fully represented. And there were consultations that held in all the 5 regions of Africa, where not just state parties, security sector activists of state parties were in the room. And that's also what resulted in the Swane Principles, which speaks to access to information and national security. So we understand the need for state parties to be in the room, and that's why you also saw that I also encouraged Madam Special Rapporteur to work with all stakeholders, including state parties, to develop a process that ensures that state party reporting and engagement with state parties is alive and creative, using the principles enunciated in the guidelines, but making sure that we give attention to the detail, because as the popular saying goes, the devil is in the detail. Now, my brother, I haven't looked at the nitty-gritty details of the Namibian ATI legislation, but my assumption is that it is largely premised, since Zoe is here, and I'm sure she played a key role in that process, it largely mirrors the provisions of the model law. And if that's the case, the issues on proactive disclosure in any access to information law are clear. So there's no reinventing the wheel. So member states, including the government that you represent, know what are the critical components of proactive disclosure. And in any ATI law, what it solves, at least 80 to 90% of the information that the public wants falls within the rubric of proactive disclosure. And that's why you see I'm pushing the narrative that to the extent that proactive disclosure is an obligation of the information holder, which in this case is mostly member states, then you need to energize a process of fast-tracking proactive disclosure. And where I would end is, to the extent that member states, in the context of public health challenges, it happened during Ebola, it's still happening in the context of COVID, deployed proactive disclosure, sometimes without even being conscious that what they were doing was proactive disclosure. What stops us from mainstreaming proactive disclosure writ large beyond public health concerns? We've seen the effectiveness in terms of containing public health. And if we agree that it's effective, that you put information on protecting public health in the hands of the ordinary citizen, irrespective of wherever they are, what stops you from putting a lot other information relevant to the ordinary citizen in their hands, using the same platform and applications that you use in the context of public health? It's just that simple. And then lastly, in the context of enforcement, you couldn't have said it much more. Again, there were practical steps that one was going to speak to, but for the challenge of time, and I see Ndishishi is looking at me, but I would recommend to many of us in this room to follow the good example of what MRA is doing in Nigeria and has done consistently alongside other civil society groups in terms of deploying strategic litigation to advance proactive disclosure. And that's absolutely important because we create a challenge where people make, first of all, there's no proactive disclosure. And when there is no sanction for failure to proactively disclose, then there's a gap. You then create a challenge where the applicant, the ordinary person on the street, needs to make the request for the information. He is denied. There is no challenge to that denial. And the public institution or private entity, because the model law is very clear, that is not just public institution. You have private entities and relevant private entities, and the expressions and the context for which they apply are also clearly detailed in the model law. Now, when there is no challenge to that, either mute refusal or negligent denial, The information holder just believes that, you know what, I can do this and get away with it. So if you don't take them to task, including through litigation, then denials become the norm. And that is why you have implementation remaining a challenge in our many countries. But this is also where the oversight mechanisms become crucial in terms of advancing the process of implementation and compliance. And this is also where the Special Rapporteur is also key, because there needs to be, like I said, partnerships between the networks and the Special Rapporteur to ensure that the oversight mechanisms play their role of facilitating implementation. But not just the oversight mechanism, the courts. I mean, colleagues, lawyers should also be keen and able and willing to provide pro bono services in the context of ATI implementation. That is not happening, and that's a failing of the bar in our respective countries and continentally. Can we push that with groups like PALU? But can we also elevate this conversation? Because there exists the African Court on Human and People's Rights. Can we possibly consider requesting for advisory opinion from the African Court on Human and People's Rights on key parts of the ATI process, including key parts of the soft law instruments that stakeholders, not just state parties, are not complying with? And if we have an advisory opinion or a range of advisory opinions that detail responsibilities of state parties in the context of the Charter, not just in the context of ATI, even in the context of digital rights, using the declaration as a guideline, what you then have is mandatory compliance obligations on member states, because the highest court on the continent would have spoken specifically on those issues. And that's the beauty of advisory opinions. And we can learn a thing or two of what our colleagues who worked on vibrancy laws using the advisory opinion have done, because they've used the advisory opinion of the African Court to engage in national level litigation that is changing the conversation on vagrancy laws of the continent. So on that note, I know I've exceeded, but thanks a lot, and I hope we'll talk some more.
Thank you so very much. A warm round of applause to Maxwell Kadiri there. And of course to Marius Lukusianes as well, of course, to join us all the way from Paris. Thank you so much for that insightful overview, Maxwell, and you certainly stole a lot of our time. But yes, we're going to break now for tea and some coffee, and then of course head into the breakaway sessions. We have 3 sessions right in Africa. The bathrooms are just, if you take the corner around the right, just straight up like you're going to the lounge area. The bathrooms are on your left side. Hoping that these breakaway sessions can happen in the next 8 minutes so that they can all kick off at 12:40 and we reconvene here at 12:55, please, if that is possible. 11:55, sorry, if that is possible. 8 minutes for the coffee break. I would advise just grab your snacks, grab your tea, and just head into the breakaway session. And of course, let's get the conversation going here. Thank you so much. May we please all rise for the national and continental anthems here.
Let us all unite and celebrate together the victories won for our liberation. To defend all sons and daughters of Africa, flesh of the sun and flesh of the star. Let us make Africa the tree of...
This conference is officially underway. We wish you all the best and all the best with the deliberations. Please make a turn by the registration point just to get your card in terms of the breakaway sessions. Thank you so much once again, and all the best to you all. Yeah.
groups are ready. So who wants to get the first shot here? It will be useful to have you here, because it's lonely up here. And we have 15 minutes allotted for report back, so that's 5 per group. And if you can do less than 5, so that the other members of your group can also fill in any blank spaces.
Great. Good afternoon. My name is Sigwetlane Pamudi, and I was the convener for the first breakaway session. We were really focused on the question of the social impacts of technology on participatory democracy and human rights in Africa. And we do have the infrastructure. There are rifts in terms of the digital divide that kind of follow the same contours as the class dimensions, the class inequalities that we're experiencing in society, both in terms of gender, in social class or categories, and so forth. And so it's really important to also be engaged with those questions. Around that conversation, there came up some really interesting ideas around, well, you know, should we perhaps not be engaging the idea of the internet as a human right, given its enabling role in society in terms of facilitating access to information, this key facilitator right in facilitating expression and other kinds of social, economic, and cultural rights, as we know, and linked to that was also the question around, well, you know, if we are going to have this debate purposefully, we also do need to be thinking a little bit about, you know, what do we mean by access, right? Reminding ourselves that, you know, in Africa, the standard for broadband access is 5 megabits per second, which can barely download an image in a minute or less. And what does that mean in terms of the quality of access that we are aspiring to if we are going to be making the internet a human right? It also raises profound questions around, you know, the state's capability as an enabler of access per se, given that, you know, if state actors aren't able to even meet that standard, well, what does it mean, you know, if we put this obligation on them to enforce the internet as a human right or realize the internet as a human right? Then, of course, there were questions around information or issues around information bubbles, which are themselves linked to access, but also around how the internet itself is set up, or technology itself is set up, received, and then processed in society in Africa. So, for instance, you know, the internet itself is fragmented in terms of who's able to participate, usually urban elites, and what does that mean then for rural-based people who themselves also need to and deserve to be included in all of this big talk around the 4IR and connecting, you know, the whole country or connecting the last billion Africa. What does it mean in terms of what kind of information they're able to access, how they're able to access it? What does it mean in terms of the role? I'm so sorry for the interpreter, I'm speaking too fast. What does it mean in terms of the role of the state in terms of ensuring critical media literacy, so that those of us who do have access and those of us who are coming into access also have the tools and the knowledge to be able to participate meaningfully from an informed position on the internet. And of course, I see the gentleman behind me already pushing me along because of time, but I think that there are just 3 key things that came up in terms of practical things that we might want to also be considering here. The first is around USAFs, you know, Universal Service Access Funds, right? Many African countries do have them in law, not all of them, of course, but these are key in terms of ensuring that there is the access that enables a social participation in public life, but these aren't being leveraged effectively, and we can see that in terms of the extent of access or in non-access that we have in the country. The second, and of course I know that we have a session dedicated to this, is the question around the anti-competitive impact of the big tech platforms on media ecologies, and the ability for people to participate deeply and meaningfully in public life. If things are not behind paywalls, the information bubbles are being created by these platforms, and there are also discrepancies in terms of how the content is moderated and the algorithmic decision-making is done to serve that content to people. And as a result, we really need to be thinking quite deeply around, well, you know, what do we do about that in Africa? We know that in other jurisdictions, such as in the European community, these things are already being addressed. And then lastly, of course, is the question of, and we heard this earlier this morning, the privacy and the ownership of data. Where should that reside? How should that be regulated? Who and how will that be enforced? Thank you. Thank you.
Let's give them a resounding round of applause. Now that the 5 minutes was used up, other colleagues in the group can feed into the engagement when we open up for conversation. So the next group. And the last group should just prepare.
Good afternoon, everyone. We were tasked with the very, very easy question of figuring out the legal and political practices shaping the intersection of information and communication rights and participatory democracy. And of course, we solved all of it in 45 minutes. We started off by looking at what is going right. And fortunately, there's quite a lot that's going really well. We reflected on COVID as a useful moment for us to see the value in ensuring we have effective laws and regulations and are using tech in a positive way. We shared some really wonderful stories about the way in which different courts, primarily at a domestic level, are engaging with the intersection of various rights, and that this enables us to have litigation pathways to use courts domestically to engage in regional bodies and figure out the ways in which the law can really achieve positive impact. We also saw significant value in us just having rights and having obligations. That's the best starting place that we have. And as a South African, we have a wonderful constitution that we love. As Africans, we've got all of these amazing declarations and treaties that we've discussed throughout the morning. So we have a good base to start off from, and we have people who are willing to fight good fights, which is fantastic. There are, regrettably, a few things that are going bad. There's a significant interpretation gap at the moment. So while we may have laws in place, bad actors or actors who may just not know better are misinterpreting the laws, and that is resulting in consequences that are harmful, particularly from a rights perspective. We're then also seeing the rise of bad tech, surveillance technologies that are being traded between governments, and there's a significant political influence here that needs to be managed. And of course, as suggested by Group 1, access is a significant issue. We can draft as many beautiful laws as we want, and they can be powerful and impactful, but if people don't have access, they won't have much meaning. Then, in terms of solutions, we've got a couple. We actually had more solutions than good and bad things, which is exciting. One of our main solutions is just about knowing the tools that we have, and this means that we need to have seats at the table. So when there are events at the Commission and the media has side plenaries, civil society should also have side plenaries and be in those spaces, be engaging with judges, be engaging with commissioners, with special rapporteurs to say, we know some stuff, we've got some ideas, listen to us, we have things to say. So we feel quite strongly about being in the correct spaces and using the knowledge and the tools that we have. And this linked a lot to sort of training judges or engaging with the commissioner and different special rapporteurs to suggest that we set up working groups where knowledge experts can join together and can work together, similar to settings like this, where we can learn from one another, understand the practicalities, understand the legalities, and know how to take it forward. Access came up again as part of our solution. And two final points, because I know time is against us, and I'm sure you are all as hungry as I am, was about making laws and political decisions accessible. So a lot of us sign terms and conditions on a daily basis, and we have no idea what we're signing or why. Our laws could be providing far better safeguards in that regard. Making the decisions that our governments take or that our information regulators take publicly accessible is really important. So having access to this type of information is what enables us as members of society to participate. And then finally, it's just about engaging politically as well. We were often cautious to engage with political parties, and rightly so. But they are levers of power, and they are members who should be in rooms sometimes. And we just want to make sure that we are working with judges, with commissioners, with civil society, and with the media to make sure that we can use all these beautiful legal tools that we have to advance rights and make sure that everybody is receiving what they deserve. And with that, I thank you.
Yes, the last group. Oh, okay.
That's right. Avani Sin will be presenting on behalf of Ms. Masters, yes.
Thank you so much. So Rihanna convened a really interesting, lively debate and delegated to me to do the report back. So we have broken it up into kind of three broad themes that we looked at around trends and harnessing information and communication rights. The first was in relation to social media platforms. And one of the things we looked at specifically or discussed a lot was around the role that WhatsApp plays as one of the most commonly used platforms in the continent. But also the fact that despite this being so prevalent, we've had very little research done around it, because in terms of where the interests lie, for example, global north countries have perhaps far less interest in it in terms of how it impacts, and so are less likely to invest resources. We've seen that there is a balance between potential measures that the platforms have tried to take in averting some of the challenges, but also that issues such as mis and disinformation, arrests, and so forth have a fundamental challenge to the way in which we exercise our rights. And some of the recommendations we looked at under this first heading was around the need for greater research, the role of regulators in the continent, and the need to strengthen those powers. And again, a key issue for us was the idea of needing to leverage as a continent in order to be able to drive or push the importance of how this impacts in Africa. The second part that we looked at was around OGP standards, including disclosure platforms, research that's being done, and a key example was around the growth in the access to information movement in the field of procurement, which Africa has been quite key on. We spoke about the role of open data contracting standards, about the need to engage and discuss and have a dialogue because of the different ways in which we see these standards being applied and the different challenges, for example, in the way that the calculations are done. And as was noted, in terms of any kind of platform or disclosure of this, the data needs to be transferable, accessible, and disaggregated in a manner where we can see the trends in terms of demographics, for example, the way in which it impacts women. Another point that came up, and this is now in terms of the recommendations under this point, is the key issue around explaining the importance of why access to information is important as a right in itself, but also the real-world impact it has, for example, in seeking job opportunities and changing that narrative. And then the third is kind of upskilling in terms of resources and a willingness from public institutions to realize why proactive disclosures are so important. And then the third and last point was around this idea of using technology for accountability and fairness. And this speaks directly to the issue of enabling human rights both on and offline. One of the key, very prominent examples or positive examples we saw was the way, or we discussed, was the way in which online platforms have increased access across different language barriers. And we had a great example of podcasts that are being produced in African languages. We also discussed sort of the broadening of access in terms of, for example, traditional gatekeepers that we may have seen. And then very lastly, don't worry, very lastly, the final point that we pointed to was that there's a lack of understanding or commonly understood terms in terms of even what we consider to be fundamental rights like freedom of expression. And we need to define these standards clearly so that all persons exercising a role in terms of public journalism or outside of the frameworks of traditional journalism also have a key understanding of what their role is in terms of what standards they may abide by, as well as, for example, in different communities, for example, the way in which rural communities are able to perform this role as well. And this requires support from a number of stakeholders and different strategies, be it advocacy, strategic litigation, or otherwise. Thank you.
So another round of applause, please. So now we have another, Undishishi, am I right? 15 minutes? Okay, so it's now a plenary conversation. Members of the groups can feed into what they heard from their rapporteurs, and then we can all discuss as a collective. So the floor is open. Just indicate by a show of hands. Yeah, I see two. Mkelani? Yeah.
Thank you. Thank you, Maxwell. In addition to responding to what has been presented, I also wanted to reflect on what you indicated earlier when you spoke about expanding the base. And I think you specifically mentioned the legal profession. It's true that this movement has predominantly been journalists and civil society organizations in the human rights space. It's important to include the legal profession as we expand the base. Yeah. However, my concern is that when governments are engaging on issues of information, communication rights, access to the internet, open internet, etc., they are conversing with the sector, with the IT sector, with big tech. And big tech is not here. Big tech is hardly ever in the platforms where we discuss these issues. And it worries me what I hear being discussed between governments and big tech, because it is not based on any of the principles that we discuss in our platforms here. So for me, it's an appeal to say, as we extend or expand the base, we need to be able to have a very honest conversation with big tech, with technology companies. Also bring into discussion issues around some form of regulation, because big tech and technology or digital platforms, of course, it enhances access to information, enhances participation, but there are also some dangers there that we need to address. I just wanted to throw those few ideas in the pot as we continue with the discussion. Thank you.
And I hope it's noted, because again, I would just want to give a case study to just drive home your point, Mkelani. I think a couple of years ago, there was the first Africa Regional Conference on Data Protection, again hosted in Accra by the Ghanaian Data Protection Authority. And it just put on display the incestuous relationship between big tech and the regulatory sector, because the entire conference was underwritten by big tech, and I can tell you it was luxurious. So luxurious that there was more time spent outside the conference than inside the conference, including on the exhibition stands. And for a full week's conference, there was just one session dealing with conversations around rights and big tech. And of course, as you can imagine, that was drowned out. And just imagine you have a convening that has over 500 people, and you don't have up to 5 human rights activists in the room. So that conversation gets drowned out, just to validate your point in the need, as we expand the space, to also bring in conversation with big, and actually not bring in, but force the conversation. And to just end with the point that, like they say, in many of these respects, technology grows in leaps and bounds, and the law is struggling to catch up with technology. And that also implies human rights protection and promotion as well. So there's a lot of work to do, and of course, in the expanding the base, that's one area that needs to be looked at. But again, I don't want to put you on the spot. I put the ball back to you, that as one of our brothers on this side, who is now within the frame where these conversations are being had, to also create that space, for us to also have a seat at the table and collaborate with the Special Rapporteur to also force the conversation at the regional level, because I don't think that has happened yet. The Commission a couple of years ago adopted a resolution on artificial intelligence, where there are a lot of things they wanted to do, but there's been no uptake on that. Can that be a starting point?
Thank you very much once again. The name is Ismail Okoyemi from Nigeria. I just feel it's also very important to re-emphasize the role that technology has played in enhancing some of our human rights, especially the freedom of expression in the Nigerian context. You agree with me, for some of us that are familiar with the Nigeria activities within the Nigeria system, that there is no way we'll be talking about participatory democracy, that we'll not be talking about citizen engagement as regards to ensuring checks and balances within the governance system generally. So by looking at that, I will refer that to what our budget tracking process is all about, leveraging on technology. In the past 8 years, I think Nigeria has done significantly well in the area of budget tracking, leveraging on technology, because when our budget has been presented to the House, to our Parliament, I think some of those issues within the budget that are contentious have been posted on the internet, and people have robust conversation about that and make recommendations to how to improve upon those things. And in the implementation of the budget proper, citizens at the grassroots adopted technology to see how they can also track the implementation of those projects and to hold leaders accountable. I think that's one area that we should also commend, and to identify that we've actually made significant progress in that area. Thank you.
Thanks a lot, Okoyemi. Yes, my sister. Yeah. Please, quickly. No, but we need to hear you loud and clear. Can we have another roaming mic,
Yeah,
please?
if we're going to expand the space and we're talking about big tech, I do think we also need to talk about our intermediaries, yeah? Especially, Seklani made the point, and I think all the groups talked about access, yeah? And if we're talking about access, we're talking about cost, we're talking about format, we're talking about infrastructure, and they are not held accountable for any of that. And unfortunately, I mean, talking about my own country, the regulator has the role of both regulating and, you know, the conflicting role of consumer protection, and I think that's a bit, you know, difficult. So I think also intermediaries need to be brought to the table.
And can this be one area where we begin to unpack part 4 of the declaration? Because there's a principle in the declaration that speaks to intermediaries. So would your group, and apologies for putting you on the spot, but since you have this brilliant idea, take on the responsibility of unpacking that principle in the context that you've just looked at? So we apply the principle at the national level, and that becomes a case study that can be extrapolated beyond South Africa. Would you do us the honor, madam?
Try.
Okay, thank you very much. I'm sorry, but I'm trying to just drill down. Exactly.
Okay, thank you.
Yes.
Maxwell, I think it's necessary for us to call a spade a spade. Big tech is not interested in rights, freedom of expression, any of the things that we are pushing. The only thing that matters is the dollar and the cent. At the risk of sounding like a broken record, because I've said this on many occasions. Firstly, we cannot deal with big tech as a homogeneous grouping because they respond differently to different settings. And secondly, we have at our disposal the Africa Free Trade Agreement, which makes Africa the biggest free trade zone in the world. That's a lot of dollars and cents on the table. So that as a point of intervention, again, stressing my point of the private sector and trade becoming part of this discussion.
Again, thanks a lot, Zoe, you flagged the point, but I'm aware that in the context of AFCTA, some of the stage 2 negotiations and processes are currently underway. And incidentally, one of the key parts of that process is ICT technology and usage. Now, can we, in terms of just building out, get a seat on the table in terms of those conversations? Yes. Yes, but even in the context, exactly. So can we force that, you know? And I think it's important as we begin to, because we need to get into these spaces and we need to get out of the comfort zone of speaking amongst ourselves to the converted. And that's the only way we can begin to make change. But lastly, on big tech, in the context of your determining rightly that Africa is the biggest market and there's so much, can we make it have a cost for them? You know, if they have different standards between the global north and sub-Saharan Africa. Because that cost, which affects their bottom line, is what will bring them to the table to have the conversation that we need to have. And again, that's also an area where the Commission also has a role to play, you know, in terms of advancing these conversations, because there are so many players that are strategic to moving it forward. Again, would you want to be able to lead us in that direction? Because we need to begin to move this conversation practically. Okay, so we have another one. Yes, Chip, please.
Thanks very much.
Apologies that I'm forcing people. I'm not forcing, I'm just suggesting.
Thanks very much, and I'm glad that the conversation has moved into a discussion about an engagement with big tech. I mean, I think we have to recognize that there is enormous power on the other side of that table. I mean, even the big players like the US government and the EU and others struggle to assert themselves against big tech. And I think if this is going to go anywhere, I think that there is an important step which involves developing a kind of common approach, at least, or a platform to, as you say, force these players to listen, basically, to implement particular steps. I mean, UNESCO has recently published a set of guidelines which are kind of urging big tech to do various things. But I think, you know, as a continent, there is a need to go further than that and extract costs, as you say, perhaps, and to be quite specific about what it is that national jurisdictions can expect in terms of data protection, privacy, competitive behavior or anti-competitive behavior, etc., moderation, and so on and so forth. But I think, you know, we have to kind of stand together. We have to develop a common platform.
Thanks, and I hope the organizers are noting this in terms of the rapporteur, so we need to be drilling down on this gradually. But I also think, again, Mukilani, apologies that I'm putting you on the spot, but you are the face of our regulatory framework, and a progressive one. So I want to push that, because you see, again, the regulators have a role to play in terms of how you force these conversations. So would the information regulator be willing to also provide leadership for us in terms of, because when the regulators speak, at least the companies listen and they come to the table. And in that conversation, can civil society and other stakeholders have a seat at the table where we have some of these important conversations that also would have the Special Rapporteur having a seat at that table as well, because we need to start building this thing out. Yes, George.
Yes, Maxwell, thank you very much. And I think that there's something I said in my group that I'll say again, following from what the last speaker said. You've referenced the UNESCO guidelines that were just published. Good news is that it's a consultation document. So this is version 3, which is still in preparation. And it offers an excellent opportunity for civil society's entry into the discussion from Africa. But again, there is something else that we need to watch. The global evolution of regulatory systems that can impact on Africa, in my view, in different ways depending on how we look at it. The Digital Services Act by the EU, the Digital Marketing Act by the EU. Just a week or so ago, the US Supreme Court decided Gonzalez, which essentially is also related to Twitter and Tema, for those who are very much interested in the law. The principles that are evolving there will define global standards one way or the other. So it's important that at this stage, African civil society, particularly interested in information and communication rights, look at what is going on there and the implications about how those who define global rules and how Africa should respond. Thank you.
Okay. Thanks a lot. I'm told we don't have, okay. All right.
I'm sorry. No, we need to move, unfortunately.
Hi, thank you for exercising your patience. We are changing the world. Good morning, everybody. I am Fauna Kay. I am a radio producer, and I'm just going to get into it. The conversation is on policies. The conversation is on inclusivity of everyone. The conversation is on change, or it's about change. From Observia, you already noticed that the current existing system and its structures does not, the current existing system and structure is what it looks like right now, and the outcomes of it. And there's a need for change. And how we can change that is, of course, by looking into the current existing policies and seeing how we can actually construct new ones that best serve social development and moving forward.
Thanks a lot. Please give yourselves a round of applause. I believe the conversation has been very robust, rich, and we're actually going to be continuing in the next session after lunch, which speaks to developing an open and inclusive internet for Africa. And I hope some of these conversations will not end here, but will be developed further in the subsequent panels and subsequent plenary conversations. So thanks a lot once again, and enjoy your ride to food.
Maxwell, thank you. Please, a warm round of applause for Maxwell, and of course, a phenomenal job that he did there. All of our conveners, our rapporteurs, thank you so much. We certainly appreciate it. I see Robin Tyson, they're typing away here at 500 words a minute. But yes, it is lunchtime. And of course, for our delegates, lunch will be taking place where most of you were last night. That's in the main restaurant area. So just on your right, you keep to your right, and then eventually go down the stairs, and you should find some delicious food made for you. All the service providers, please remain behind. I have an announcement for you guys. Furthermore, with delegates, please note on your way out here, please collect a coupon for your drinks. We want to make sure that you wash down your food properly. So please do collect that coupon on the way. And of course, we'll see you at roughly 2:30. Enjoy your lunch. Interact as much as possible. And of course, we're looking forward to continuing the great conversation. Thank you once more. How many of you tried the Namibian beef? Please put your hands up. How many of you had beef? Only 5 people, really? I guess the rest of you guys missed out. If you didn't know, Namibia does have some of the best beef in the world, and I'll certainly encourage you to try some later on this evening when we have our dinner. Thank you so much for staying with us once more. It is, of course, the 2023 Regional Conference on Information and Communication Rights in Africa, organized by Fesmedia Africa in partnership with the African Commission on Human and People's Rights, as well as the Namibian Media, as NMT, as well as a UNESCO Namibia office. Thank you so much for staying with us once more. Of course, we have a program, a very packed program. I just want to go back and thank Mr. Maxwell Kadiri, who, of course, oversaw the earlier session on an open and inclusive internet for, the mapping the legal and political practices shaping information and communication rights and participatory democracy in Africa. Of course, these were some of the conversations that took place as part of the bigger conversation around advancing access to information and human rights in the digital age. And of course, the overall landscaping was provided for there by Maxwell Kadiri. If you're just joining us right now, thank you so much. You are, of course, watching, that is the 2023 Regional Conference on Information and Communication Rights in Africa. If you are watching us via social media, please share the stream. We are on the Friedrich Ebert Stiftung, that is Fesmedia Africa, across, that is YouTube, Twitter, and Facebook. Share, and I hope many of our delegates have been taking pictures as well and sharing some of those on our various platforms. Thank you so much for coming back once more. I would like to move on with the program for this particular segment. We do have Nashilongo Gervasius in our midst. She'll be providing the landscaping on an open and inclusive internet for Africa, a practical possibility or pipe dream. That is the big question. And of course, Nashilongo will help us answer that question. Please put your hands together for Nashilongo Gervasius.
Thank you. Thank you, Ndishishi, and good afternoon, dear delegates. It's good to be together today. I think I've already been introduced. Please allow me to spend a bit of time to take you through what I've come up with is a canvas on really investigating an open and inclusive internet for Africa and whether that is possible. All right. I might be having some tag issues. Next. Where do I point this? Somebody? Oh, yeah, right. Okay, so I should be. Thank you. Thank you very much. I was looking. Fortunately, only covers about 7 African countries. So in beginning this scope, I thought I could just reflect shortly on the AU PRIDA. I'm sure a number of us here are aware of PRIDA, which is the African Union project that dealt with policy and regulations initiatives for digital Africa. It's a 10-year project, and it developed a couple of initiatives. One of those is the Africa Digital Transformation Strategy for Africa, which is also 10 years and ending in few years. Of particular interest from PRIDA, I would want to highlight the two of the last objectives that you see there. One is the harmonizing of measurable ICT telecommunications policy, legal and regulatory framework, as well as the strengthening of the ability of African stakeholders to actively participate in the global internet governance debate. A key output also focus here is that output number 2, which is continental harmonization of ICT policy, which particularly possibly will lead us to the answer that we're getting to today, looking at the regulatory and legislative framework through the development of a monitoring and evaluation system and enhancing cooperation between telecommunications, regulatory authorities, as well as raising awareness of public authorities and civil society regarding cross-cutting use of ICT. So in moving on, particularly on openness again, with regards to the UNESCO ROMAX assessment, maybe I'll just pause at this point and just try to find out if anyone in this room is aware of the UNESCO ROMAX, or what UNESCO calls the Internet Universality Indicators. I see a couple of, okay, 1, 2, 3, couple of hands. Yes. This is home advantage, Luis, over there, but thank you. Thank you. It's good to know that there's, this is a familiar framework that UNESCO produces. It is it contains 303 indicators. It's a result of the WISES meeting of 2015 and a couple of updates have been done to those indicators. I want to believe on openness as a category, I think there's about 76 indicators, but of those, I will only be looking at few of them, what we call the core indicators. Once again, this canvassing is focusing on those 7 African countries: Kenya, Benin, Senegal, Tanzania, Namibia, Zambia, and Mauritius. You may want to ask why. Kenya, Benin, and Senegal is one of the 3 African countries who have already completed the UNESCO assessment, and Namibia, one of the countries that's currently undergoing this assessment, and the other countries are for interest countries, but of course relevant. All right. So in our canvas, we picked a couple of indicators, as I've mentioned, and it is specific indicators, what I call core indicators, that speaks on openness, and this is is what gets us to the results today. Please bear with me. I hope you can see what I see. Maybe not. But one of the indicators that we looked at is, for instance, one that is asking on overall policy, legal and regulatory framework, for internet development and policy making process, which is consistent with international norms concerning openness and transparency in particular. The other is one that deals with innovation. The next one deals with asking other restrictions in organizations, on which organization or individuals establish internet or internet-enabled services, sorry. And the other is an indicator that's asking if whether national standard setting processes conform to international standards, including due process and transparency, and whether the government promotes diversity of intellectual properties. That one also speaks, and you would possibly understand a bit later on why it speaks to issues of openness and accessibility and inclusivity for that matter. And then the last indicator that we have here is one that is asking if governments of the 7 countries promote and adopt standards to facilitate accessibility to the internet and e-government services to persons with disability. So those are the ones that we've picked from the policy, legal, and regulatory sort of indicators on mapping this landscape. And what you see, we hope, is a good reflection of what is happening in those countries based on our canvassing. Moving on, again, still on openness, but this time around looking at indicators that deals with open content and open markets, which is very more closer to access to information, for instance, and freedom of expression, are those that deals with open data, for instance, really looking at whether these countries have open data frameworks or open data policies in place. The next one also asks whether government requires ISPs, for instance, to manage network. This speaks on issues of transparencies and non-discrimination, but also more particularly on net neutrality. The next one speaks on the legal usage of VPNs within those countries, and this is also, those indicators are some of what looks like in those countries. The other is whether individuals or organizations are able to share data that is previously shared by or made public by government, for instance. The next indicator speaks on government departments and local government agencies, on whether they have websites which are available in official languages and through other major browsers. I think that was a very interesting one. And the second last speaks on open data by stakeholders, in which it is used for sustainable development. The other also deals with legislations, particularly on access to information and whether that's in place in those countries. Moving forward, and I think this is possibly the last of the indicators that we've picked. This one looks at the open standards in ensuring openness of the internet or internet availability within Africa. Here we have indicators that speaks on independence of the regulators, for instance. Please. And we also have the one that asks on the independence of management on domain name systems. One also deals with this effective competition, communication access networks to protect consumer interests. And of course, one asks, can the internet users choose really on competition issues and choices of usage, from ISPs to name registers to online services, amongst others. The last one, or second last one, asks on whether communities are able to establish community networks. As we know, in the internet space, community networks have become one of those platforms that allows or provides access to people onto the internet. And of course, the last one deals with the issues of exchange points, where we found that, for instance, in all of these countries, the availability of exchange points within these countries are there, whether they function and whether they function effectively. I think that's a question for that we are going to get to at the end of the day. And not only that concern or concern comes up on internet exchange point in particular, but also we see that, for instance, on issues of the independence of the regulators, amongst others, and the sufficient effective competition amongst players. All right. So we wrap up on openness. If okay, I would go ahead to quickly look at inclusivity. So inclusivity from our landscape really looked at a couple of things, and those anyway have also been covered already in some of the indicators that that I have reflected on earlier. The usage of, or the making use of the multi-stakeholder model processes in the policy making processes, ensuring gender as part of inclusion, disability as a key concern in inclusion, as well as education. And with education, we also look at the language and cultures. Right, so overall, we were answering few questions, actually a lot of questions, maybe about 7 questions, so please bear with me as I continue. So number one question we were asking is, in the development of an open and internet and inclusive internet in Africa, what are the challenges and how can they be overcome? So we highlight issues of policy, we highlight open standards, we highlight open content and open data and open government as major challenges based on what we have canvassed. Moving forward, the next question asks on legal policy and regulatory for equity and access, and whether these countries could give us some directions on how the Africa landscape look like. This question asks on what needs to be put in place to ensure that the equitable and accessible internet for all in Africa is in place. And those are some of the responses that we have come up with. For instance, prioritizing technology-related laws that protect, that ensures privacy and protection of the users of the internet, ensuring that the specific regulations are protecting special interest communities, for instance, such as journalists, human rights defenders, women and people with disabilities, legitimate authorities to enforce compliance against data offenders, access to information legislation, open data laws and regulations, and research and innovation, as well as a liberal regulatory framework would be some of the legal and policy and regulations that would enforce or ensure equity and access of the internet on the African continent. Moving forward, the next question asks us, how can the technology companies and government work together to ensure that the internet is used to promote human rights, democracy, and rather than hindering them? We've provided some of these responses, but maybe before I move deeper into details, we could come back to these ones, Ndishishi, after our breakout rooms. And please allow me to, at this point, only stop here and then ask for engagement if there are any. So yeah, a quick one on the questions. The next question asks about technology companies and governments and how they can work together to ensure that the internet is used to promote human rights, democracy, and rather than undermine them. And the next question looks at what are the roles of the government and civil society organization as well as private sector plays in the promotion of open and inclusive internet for Africa. And I think finally, if there are any lessons, and we would like to hear from you, and whether here or in the breakout rooms.
Are we still stuffed from the lunch, or what is going on? Any contributions? Any comments, sentiments?
Sorry, the last 2 slides were a bit quick.
Yes.
Could you leave it on the role that governments play, and then the next one, the lessons that should be learned from other regions?
Okay.
Thank you.
Mm-hmm.
All right.
So there's actually a couple of them.
Nashi, we have a question here.
Yes. Thank you.
Great work, really appreciate it. But again, it's one of the things that I wish to draw attention. When I see advocates and activists particularly rely particularly for policy influence in the communications sector in Africa on UNESCO data and principles, it also speaks to part of the disconnects that we need to deal with. First of all, I am somehow closely related to the work of UNESCO. I just returned a week or so ago from a UNESCO Executive Board meeting. The big decisions on communications and technology happen at ITU. Okay. And the African ministers who are taking the big decisions on these issues are at ITU. Most of the, whether it's the permanent delegation or our delegations to UNESCO, tend to be working more on education and science issues. So there's a huge disconnect, even at the global level, between what happens at ITU and what happens at UNESCO. Mm-hmm. So I want activists to begin to look also more at what is happening at ITU. Questions about spectrum use and the rules that guide that happen at ITU.
Correct.
So that is the point that I want to put on the table, because going forward, it is that space that would need to begin to look more for the changes that we expect. Thank you very much.
Thank you.
Sorry, I think there is need to clarify. I come from UNESCO. ITU deals with the infrastructure when it comes to the digital spaces. UNESCO deals with the content.
You are going to see that in almost every country, the policy questions are driven by infrastructure questions because of what we all know, convergence. Mm-hmm. So if you are dealing with convergence policy today, the old questions about content and infrastructure breaks down completely. So all across our countries, you can check, Namibia and a few countries are the only places where you have both information and communications as ministries united. In almost all the countries, the Ministry of Communication is different. Maxwell is looking at me. You would see that in Nigeria, you see what is going on in terms of these issues. So my advice is that it is not to jump away from UNESCO, but to understand that the questions that will affect you more, cybersecurity questions that are now framing, that's where everybody is hiding new laws that restrict access to information. That is happening within the communications field. Do you understand? So whilst we watch this side, it is important that we know that the risk that we are fighting is happening elsewhere. And so advocates need to begin to look more at what happens there. Spectrum policy, going forward. How much spectrum are we leaving for broadcasting? How much spectrum are we leaving for telecommunications? That decision is happening at ITU. How much space we are doing digital migration in Africa? In the whole of Region 1, we are moving television broadcasting away from 900, 1800 megahertz, pushing them to 1500 megahertz. What is the implication for that? Okay, for access to information. They always come like technical issues, but it is not. Let me give you my last example that I think I see that human rights advocates are not watching. All across Africa now, we are migrating from analog to digital broadcasting. The approach to it is that in almost all our countries, we are building one broadcast digital signal distribution company. In Nigeria, in Ghana, in Namibia, in South Africa, almost everywhere. What that means is that within the next couple of years, all broadcasters, especially with television, are going to channel their signals through one broadcast signal distribution platform. And in almost all these countries, that platform belongs to government. In the next couple of years, it would be very, very easy for a government that does not want broadcasting to happen to just switch off. Our friends in Kenya may share with us an example that happened. In the election before this one, when Raila protested and said he was going to swear himself in as president, most of the analog channels went off. Check. The digital platforms went off. But because they were in simulcast, so some of the analog platforms were still broadcasting. That is how most people got to see. If we don't watch those spaces, I'm sorry that I've spoken for too long. The point is going to be that we will come back to chase a mirage. And I really want to recommend that we need to begin to watch more what is happening in what otherwise looks like the infrastructure space. Thank you.
Thank you. Thank you so much. I had just pulled back my my slides up, and if you look at them, we have a lot of spectrum indicators as well that we use to measure openness. That openness is not just a policy issue. To a large extent, it is shaped by infrastructure. Just amongst others. Right. Thank you so much. Yes. Let's hold on.
Hi. Can I just say something? I don't disagree with what the colleague has said about infrastructure and content, but I think there's another challenge that we maybe not dealing with is the fact that let's accept that the ITU deals with infrastructure, and those are very important questions. But on the content layer, our legislation is way behind. Broadcasting is a platform. The reason we have no jurisdiction over many of these streaming companies and big tech is it still refers to broadcasting. That is not broadcasting. That is on the IP layer. And therefore, we should be looking, if you want to get inclusive regulation, if you want to move to a situation where the streaming companies and big tech are under jurisdiction, you have to fundamentally overhaul our laws at the content layer, because broadcasting, it's just one form of distribution now. And in fact, in our country, the digital terrestrial distribution is the smallest broadcasting platform in South Africa and will probably remain that way because of the delays. Satellite is still by far the dominant distribution. Once analog gets switched off, satellite is still the biggest, and the DTT will be small. It might be different in other African countries. But the point I'm trying to make is, if you look on the statute books, and others can correct me if I'm wrong, if we've made that jump to what Europe has done, where they call it audio and audio-visual content services, which would have broadcasting as a subset of that, only a subset. And that would include all these other companies, which may be subject to light or heavy regulation. But I just think we need to get our regulation at the content layer right, and I think that's way, way behind. Thanks. Michael Markovitz from South Africa.
Thank you. Thank you for your input. There was a hand here, and...
Okay. I actually just listening to the gentleman here, and looking at systems and the way they are structured, looking at especially policies that give these systems power. And I mean, using that same space as the media to actually hone into the power that we have to influence the change that we want to see on the ground. And also, as a media practitioner, what I have noticed just from COVID, the subject of COVID, and how it landed in almost every country, and how it had what looked like a business plan that was already structured and with points and also regulations, but with the fact that we do not know where this is coming from. and how the media was able to be the influence to get this information on the ground. And so just in knowing that we do have the power as the media, but at the same time, how we utilize it is what happens in terms of ripple effects of the outcomes on it.
Thank you. Just a quick...
Sir, can you just hold on and see if there's any other hand? I'll give you an opportunity. Any other input along the room? In that case, please go ahead.
So and I'm really happy that the point we sought to make gets better clarification even from our colleague there about the fact that as we look into the future, we need to keep our reflections on both these content issues and infrastructure issues because of convergence. And that if we are not very careful, we'll be overtaken. So he just introduced a very important question about satellite, for example, which even complicates the discussion further. Because today, anybody who is doing broadcasting, you just set up a simple mast with a simple transmitter, you're good to go. Very few companies, content delivery companies in Africa are going to be able to launch a satellite. You understand? So if we are even transmitting by satellite, simply because of the politics, okay, of the entire electromagnetic spectrum, the geostationary orbit issues, governments are going to have greater control in terms of access. Or whoever is going to own and control that needs to be part of our reflections when we discuss these issues at this stage. Who owns them? Who is operating them? What rules guide them to secure the human rights and free expression orientations that we are interested in? So it is only to broaden the minds of advocates to the challenges as they are likely to emerge so that we can contain them. Thank you.
Thank you. Thank you so much. Sir, Dishisha, do I hand it over to you just to tell us what happens next, and then we come back to the room.
Yes, thank you very much, Nashilonga. I'm glad there's so many questions already for this particular plenary, and I think the breakaway session should be much more interesting. So we'll have 3 sessions in total. Group 1 will be led by Penyo Sakati, who's of course our convener for this session. Penyo? There she is. So if you're finding yourself in Group 1, you guys are in Oryx 5. That's just across the registration point. And you guys can, of course, engage in that particular breakaway session on universal access to the internet in Africa, the state of play, risks, and opportunities. Our next convener is Admire Mare. Admire, where are you? Oh, there you are. Fantastic. Of course, Admire will be convening the session on building open and accessible digital landscapes in Africa. What is happening and what more is required? Those are the pertinent questions. They will be right next door over here. Group 2 will be right next door over here. And then Group 3 will be in this particular venue, being led by Avani Sin. Avani, you're shining today, hey? Avani will be our convener for this particular session on building safe and inclusive digital landscapes in Africa. Of course, we do have an hour for this particular session, and starting now, so 4:15, I think, should be a fair time for all of us to come back and report back and, of course, engage on this very, very important subject. Nashilonga, with your permission,
thank you.
May we go?
Thank you, yes. Please
all right,
go ahead.
fantastic. See you all very soon.
Cool. So we're going to. Cool. So we're going to start with this group, and we've had a really nice setting of the scene with the previous speaker, but we're looking specifically at safe and inclusive digital landscapes. And I think as we've all been having the conversation, trying to find practical recommendations and opportunities going forward. So I've just broken it down into a couple of different points. Part one is just trying to understand what we mean by safe and inclusive. Part two is identifying the key issues that Fesmedia identified and kind of have put forward. And the third block is really broken down into two parts, which is any other key issues that we think should be raised or discussed, and then most importantly, our recommendations going forward. As to part two, I have suggested 3 questions which I think are particularly interesting, but that's just my thoughts on it, and again, we'll open this up to discussion among everyone. So just to kick off with the first part, obviously we won't spend too much time on this, but the idea of what we mean. Oh, I beg your pardon. Sorry. What we mean by safe and inclusive. And these are a couple of examples of definitions, and at least just starting with the first one, which says that digital inclusion is defined as equitable, meaningful, and safety to use, lead, and in design of digital technologies, services, and associated opportunities for everyone, everywhere. Just pass a couple more down, please. Cool. So, So if you look at the first definition and the way in which the UN Tech Envoy has sort of referred to digital inclusion and included the use of the word safety as part of that definition, are there other elements to the idea of digital inclusion and safety that you think should be added or expanded upon? Should safety be a sub-part of inclusion, or should we treat them as different standalone concepts? Anybody have any thoughts? And do you agree with the definition? William, I'm going to kick you under the foot to start us off, if that helps.
I mean, I guess you'd need to just unpack equitable a bit, because of the gender dimensions around. Well, equitable could be access for rural versus urban, poor, wealthier, etc., but also on a gendered basis, and also if you consider children and young people particularly, and their rights. So if it's, I mean, I think you could easily squeeze that, you could schmuckle that in there, but I do like the inclusion of safety as an aspect of inclusion. But then, the thing that I would add, they've got meaningful, but I suppose it would just be inclusion. You have to have the skills to know how to use and understand digital, which is otherwise. So I don't know, that may be included in there.
So you asked whether they should be together as they are now, the equitable and safety. I think safety is quite big in itself, and I think it would be swept under if it is classified under equitable. And I think it's very important when you talk about safety to use. We need to expound a little bit more. What exactly are we looking at? And what are the challenges to ensuring this safety? So I think it's quite a broad spectrum when you're talking of safety in itself, digital safety, as well as the issue of equitable. So I would propose that you look at them separately, but that's my suggestion.
Thank you.
My comment is on equitable. I think most of people, when we hear equitable, we mostly think on gender, maybe men and women, but we have people in villages where the infrastructures are very bad, but also we have people with disabilities who they need more attention when it comes to digital spaces. The inclusivity needs to be looked with maybe the third eye. So I think maybe this could be more expanded to include all the groups that exist.
Thank you so much. I think that's really helpful, and I think part of the discussion going forward would be perhaps how we would like to see these terms circumscribed or expanded on. So now going to kind of more of the meat of this discussion. As you can see, Fez identified 7 key issues that they would like us to debate. Obviously, there isn't time for all of those. I've identified questions 2, 4, and 6 as ones that I find interesting. But of course, please don't consider it limited by that at all. You know, we can discuss as many of them as you want or leave these out. But I think I'm going to start with, number 4, actually, and then come back to number 2. Number 4 says, what role can governments, private sector, civil society, and international organizations play in promoting and ensuring openness of the internet and digital technologies? And then again, some of the opportunities and challenges. And I think it ties in well with what number 5, specifically around what can be done to promote openness of the internet and enhance data interoperability. So across the group, can you point to some good examples or concrete examples where things have gone well, or even particular strategies or that you've seen that could be harnessed for across the different stakeholders to promote the openness of the internet?
Thank you. Maybe as a positive example, the Institute for Public Policy Research here in Namibia led a process, I think they call it the Namibian Charter on Digital Rights or something like that, but they brought together pretty much civil society stakeholders, government stakeholders, mainly civil society and media, but to agree kind of on basic principles around digital inclusion, how to deal with data protection, like at the very like common denominator, least common denominator level, which was a helpful platform to also create a common understanding of what the issues are that we need to address. It's probably work in progress, but that I think was a good role that civil society played in terms of galvanizing a common position that you can then take to government, into public policy processes, etc.
Thank you. I think I'll comment on the government. I think as African governments, especially in Tanzania, they have firstly to educate themselves as the leaders and understand effectively the digital space and how it works. Because we expect leaders to make the laws and policies that will be friendly to us as users. So they need to understand the space and the challenges that the users are facing when are using digital spaces. There is an organization in Tanzania called Media Convergence. It did a research on 2021 to women politician participation in digital spaces. And the interesting part is that 70% declared that they experienced cyberbullying, and the rest said they experienced other forms of online gender-based violence. But 55% say that they don't know if there are laws and policies regarding gender-based violence in Tanzania. So you can imagine that those are the leaders, and we expect them to go and campaign for digital safety, inclusion, and the laws that will govern the digital space, especially when it comes to cyberbullying and other challenges that makes women to be left behind in their inclusion. So I think this it gives us a picture that they don't have enough knowledge on the advantages of digital space. And if they are not present in digital spaces and they don't participate, that means they cannot have voices to say what's exactly happening because they also have left behind. So I think the most important thing is them to educate themselves. Maybe civil society can educate them and give them awareness on how these digital spaces and tools are very important in this current world. Thank you. A cyberbullying case. So when I went to balance the story to police gender desk and cyber
you have organizations that are, grassroots organizations starting to deal with these particular issues. I think it's also very important.
On the just to add briefly on the concrete examples that you asked about, at least in the past year or so, in the states that have reported before the Commission in their periodic reporting cycle, it's very hard to get information from state parties on specifically the item of internet access. A lot of reports at first instance don't even mention digital rights. They mostly just focus on these are the newspapers that are in circulation in our country.
get into your rooms, Prof. Mare, Peños, and Avani, and just listening to your conversation. Very, very interesting conversation. I will kindly ask, I'll call you up in a minute, but as you come, please prepare to just give us a report what the discussion looked like in your room, and also help us to answer the question whether an open and inclusive internet in Africa is a pipe dream or or can be a reality. Thank you. So I will start with Peño Sekati, Ms. Vic.
Good afternoon, everyone. Hope everyone can hear me. Thank you so much for the support. So we had a very, very interesting conversation. An hour is definitely not enough to tackle the question of universal access to the internet, risks, opportunities, and states at play, but we did cover quite a bit. Firstly, we started off by contextualizing, internet access, and outlined how internet availability does not always result in internet access for many people across different groups. And so we proposed an intersectional approach to the provision of internet services and the use of platforms with regulations that acknowledge the experiences and challenges faced by different groups, by women, by persons with disabilities, by sexual minorities, by persons living in rural areas, etc. And then we asked ourselves whether the internet is a justiciable right, so whether we can actually access the right to the internet. We had a bit of a back and forth, and we realized ultimately that the internet is a mechanism to which we can access the right to freedom of expression and the right to access to information. And so, although we might not be able to go to the courts and argue on the right to the internet, we can argue for internet services to be provided in order to give realization to these rights. A couple of challenges that we faced were power asymmetries between countries, governments, and big tech, capabilities of governments, and also threats that come after we achieve internet penetration. So with the issue of government as a role player, we acknowledged and we saw that there are instances wherein the government is not capacitated to actually give, realization to this right. The courts can make their mandates, but if the government does not have the resources, the government does not have this resource. And to that, we sort of looked at the role that private actors can play. We looked at the liabilities that they have, and we acknowledge that even in those instances where private entities do hold responsibility, there is an issue of power asymmetries between these big multinational corporations, these big ISPs, and us. So that was a challenge that we looked into, that is a challenge that we grappled with for a while. But some of the recommendations that came from these discussions was firstly to mobilize community organizations and to actually invest in them a lot more. So potentially supporting SMEs would help alleviate the sort of dependence that we have on these other actors. Giving meaningful, focusing on Principle 37 of Part 4 of the Declaration to Freedom of Expression and Access to Information, which is providing meaningful access to the internet, or to meaningful access to the right to information through the internet. We shared a couple of best practices that countries have adopted, different countries have adopted in minimizing costs to data or expenses related to accessing, internet services. And a very interesting point that was raised was bringing Parliament to the fore. So having conversations with the people who actually draft the laws and actually change regulations is very important, because effectively they are the ones who they are the ones who can affect the laws that we can actually use. Use during strategic litigation processes. We also propose having specific policy proposals that we present to online intermediaries, ISPs, and also to the government, and potentially also imposing fault or no either fault or no fault based liability mechanisms on these online intermediaries, depending on the services that were provided. So that is what we discussed, and thank you.
Thank you very much, Penyo Sekati, on that wrap-up of your group discussion on universal access to the internet in Africa. I will now call Prof. Maya Mare to come and report on his group. Prof. Mare, you have 5 minutes.
Thank you so much. Thank you so much, Nashlongo. Good afternoon. I'm going to report back based on what we discussed as Group 2. Our topic was around how do we build an open and inclusive digital landscape for Africa. What is happening? What are the possibilities going forward? Is what the Group 1 has already pointed out. The issue that was also tackled in our group was the fact that as it is constituted right now, especially the digital landscape that we are currently using, it reproduces some kind of colonial relations in terms of the way in which it functions. So what you see online, for example, you tend to see English being the dominant language. What you also see, the cultures that are also being foregrounded are mostly cultures from the global north. So Africa somehow gets caught up in this geopolitical tug-of-war between China and North America, so to speak. So that is something that was really emphasized. And also some people in the group were also of the opinion that if you look at the amount of money that is actually being set aside for content moderation, for example, a lot of it is actually set up for content moderation, especially in the global north. So us in the global south, especially Africa, we are not given a lot of attention when it comes to content moderation, even fighting. Even if you look at the attempts to fight around disinformation, for example, there's little money that is actually being put towards fighting disinformation in the global south. And that was also emphasized as something that is currently happening, which is a challenge going forward. The other issue that was also raised was the issue of saying, where are the African languages? If you look at the African languages on these platforms, where are they? So Africa tends to be presented as a platform where Africans, when they go online, they go to download what has been uploaded elsewhere. And as long as Africans are not uploading something on these platforms, the digital landscape that we have reproduces pretty much colonial relations that we have seen. And also, something that was also very fascinating in our group was that it reproduces the debates that have been done and had, especially in the UNESCO framework, for example, for those that are familiar with the debates around UNESCO, the New World Information Order, where there was an idea, an argument that most of the information is actually flowing from the global north, going to the global south. And the argument was that if you look at what happens online, again, it reproduces these same dynamics, but in a totally different context. And we really need to think through how we can disrupt and dismantle that kind of colonial matrix that continues to manifest itself in digital spaces. So in terms of what's the way forward, I think in terms of the way forward, there were a lot of issues that were raised. One of the issues that was raised by our colleagues in our group was that there's a lot of technical support that is actually required, especially for regulators, but also even for policymakers, so that they understand the back end of what actually happens in the digital landscape. Because most of them, they don't know, and that's why even if you watch what often happens, for example, when Mark Zuckerberg or these executives from TikTok are called up by Congress in America, you can see that even the congressmen don't know what actually happens and how these platforms actually work. What more about here in Africa? It's even going to be even worse. So those are some of the issues that were also raised by our colleagues. But the other issue that was also raised was that we as Africans, we still need to talk about a conversation around what kind of new digital imaginaries do we need to foster in this platform so that we can also have our own alternative platforms. And I think the argument was that if we are talking about alternative energies, especially when it comes to oil and gas, why not talk about alternatives at the level of digital technologies or digital platform companies? Why are we not investing in that? And again, I also like the idea that was also brought countering that kind of an argument. And some people were saying, if we take that route, we are leaving the elephant in the room. We are trying to run away from focusing on big tech. Yes, big tech has to be held accountable, and we also need to invest in alternatives. So I think it's a dual process or a dual strategy that is needed. On the one hand, we invest on alternative, but on the other hand, we focus on making sure that there is accountability at the level of big tech. And I think that was something that was also emphasized in our group. I think because of my time, I'll try and sum up. There was also another discussion that was also made with regards to the need to make sure that we have got progressive policy interventions. And here we are looking at policy interventions that is backed by evidence-based research. So you can't say algorithms are biased towards Africans when there's no research that has been done to inform that. And I think there's ample need for Africans to invest a lot in that kind of research ecosystem so that we understand what actually happens on these platforms, so that when we say we really need auditing of algorithms, we can do that on the basis of something that is tangible. But right now, it's hearsay in terms of what people actually say on those kinds of platforms. I see that my time, and also I think the other issue that was also raised, I think, was to the fact that we also need to have coalitions, for example. Coalitions, for example, right now, if you look at what is happening in Kenya, Kenya is taking Meta to task around content moderation. But that is a siloed approach because Kenya is doing it alone. What about other countries in Africa? Similarly, if you look at what is happening right now in South Africa, the South African Competition Commission recently gazetted an inquiry that they want to make in terms of the anti-competitive behavior that big tech is actually having in terms of the influence that it has on traditional media. But it's only South Africa and Kenya. Where is the rest of the continent? So I think there's need to make sure that the continent speaks with one voice when it comes to these issues so that at least our concerns can be heard. If you have to look at what has also happened with the European Union, but also what has also happened with Australia, for example. I think because of my time, I'll probably stop there. But just to say that again, one more. Just to say, the issue that also came towards the end of the conversation was around the extractivist nature of the business model of big tech. And I think the argument there was that we really need to understand how that extractivist model, where most of the media players in Africa actually are being captured into, actually also frustrate their growth, but also endangers their media sustainability. So there's need to make sure that we understand what is really happening in that kind of space, so that at least we can be able to make forward-looking, but also very progressive policy interventions at that level. But over to you, sorry.
Prof, are you done now?
Thank you very much, Prof. Admire Mare. Ms. Avani Singh, please come through as we clap our last hands for Dr. Mare.
Hi, everyone. So our breakaway group looked specifically at building safe and inclusive digital landscapes in Africa, both of those elements being ultimately key to building a version of the internet that we want and can trust. And we looked at a couple of different ways in which the idea of digital inclusiveness have been defined. And one in particular we debated was that of the UN Envoy on Technology, which provided that digital inclusion is defined as equitable, meaningful and safety to use, lead, and design of digital technologies, services, and associated opportunities for everyone, everywhere. And while broadly the definition raises quite key elements, one of the key points that we discussed then is where it is lacking, where the details come in are around issues such as equitable, meaningful, and especially safety. And here, while within the definition of inclusiveness, it considers safety as one of those elements, in fact, safety itself is so important that to conflate the two of them as opposed to recognizing them as self-standing elements can be problematic. Overall, our discussion took a number of different turns, but just to summarize, I think our recommendations can be broken down into 5 parts. And you'll see that they're interlinked and flowing. The first is around the question of training, and I don't think that's new to any of us. The idea that training in general, broad-scale training is important, but especially those who are decision makers or regulators or lawmakers in the space. That includes politicians and parliamentarians at the domestic levels, but also at the regional and international levels, including, for example, the African Commission. It includes judges at all levels as well, and as the key decision makers, them needing to understand both the technology as well as the impact of that, and law enforcement officers who are investigating these key issues. And in creating a safe space, making persons coming forward, reporting on these issues, making sure that they feel comfortable to do so and are protected when doing so. That leads on to another element of media and information literacy, which has come up in the previous 2 reports as well, on a broad-scale basis and empowering different members of different communities to be able to roll this out. But one key issue that came up is, in fact, the role of the media in expanding media and information literacy, and in particular, the role that community media can play in rolling it out in different areas, in different languages, and in different methods. Again, linked to the previous one, we looked at the distinction between needing broad-scale training as well as specialized training. And I think in different circumstances, both of them have a huge role to play, but based on the specific nuance of that situation. Essential to all of these points was the third element, which was around the way in which we engage with marginalized and overlooked communities in making the internet safe, inclusive for all persons concerned. From a safety perspective, some of the key issues that came up are the way in which women and children engage online, the harassment that they're faced, the lack of understanding of the implications of what can be done, and especially a particularly overlooked group being the elderly and the way in which they can be affected through a lack of understanding or naivety or just being quite simply excluded from discussions because of their inability to get online. Now, the key issue raised was around persons with disabilities, and here we had a very interesting conversation about the different aspects that come into play. In particular, there are 2 kind of key elements to this. One is the cost of the technology, and the other is the availability of it online. And while there are sort of mechanisms that can be used, the issue is that although we have excellent existing standards at the UN and African levels in terms of rights of persons with disabilities, those are not being implemented or enforced or treated with nearly as much engagement as it should. The 4th point was around rights, specifically looking at the right to privacy balanced against the right to freedom of expression and engagement online. And I think a key element of this was part of the discussion that we had was, in fact, this shouldn't necessarily stand at opposites or to each other. In fact, privacy should be seen as a key element to being able to enjoy a safe and inclusive internet, and should, in fact, make it more likely for people to want to engage online. Again, while we see excellent legal frameworks, whether it's domestic laws and so on, we struggle a lot with the issue of oversight and implementation. For example, one of the issues that came out was that in terms of state reporting to the African Commission, the fact that privacy is not a right in terms of the Charter often means that states don't report on it, even though the revised declaration specifically requires states to add that into their state reports. Challenge is, in general, an asymmetry between the information available and the ability to access information online, whether that is between individuals and states or across the board in terms of tech platforms. And that is something that needs urgent attention. And then lastly, we spoke about what kind of solutions that we would be looking for. And I think commonly we agree that creative solutions now more than ever are needed. One of the considerations we had is that often access to the internet and information rights gets treated within specific mandates, so quite specifically within the Special Rapporteur on freedom of expression. But actually these are such cross-cutting rights that in considering these issues, it is also important to tie them in with the way in which other rights interplay. Lastly, we spoke about sort of the differences between multi-stakeholder convenings versus specialized, and being able to use that specialized skill to expand it to make this more realizable across the board. And lastly, the need for all stakeholders to harness the opportunities at different convenings, like the convening we're at today, to really think about how we engage, the best mechanisms of that, and how we take it forward. Thanks.
Thank you very much, Avani. Ladies and gentlemen, I think our conveners has helped us to get to the question that we are asking, which is an open and inclusive internet for Africa a possibility or a pipe dream, given just what we've had now? We are dealing with issues of policies that are not cohesive. We're dealing with infrastructure challenges. We're dealing with capacity of the media, but also of politicians that deals with these policies. We're dealing with lack of coalition, issues of disabilities not being considered, so many issues that we're dealing. So at this point, I will leave this up to you to get to the answers of whether this is a pipe dream or a possibility. And in that access, while Ndishishi is coming back to take his room, maybe I will...
Your job isn't done yet.
Oh, really? Okay.
So
I thought my job is
part
done.
of the engagements falls
you.
within your jurisdiction as well. So we want to hear any input, any comments, any sentiments really from the room as far as this particular topic is concerned. I see I have Mr. Minard already here. So another one here. Here you go, sir. But we'll take Mr. Isaac first, and then we'll come to you.
Thank you. So the first point I want to make is about, so what if we were part of the 50–60% of African citizens without access to the internet? How would our lives be different to what it is? So, if I read Principle 37 in the Declaration, just about everything that we discuss now, from all the feedback, it's all covered in 37. The single biggest change that can be made to the quality of life of African citizens would be, no, I shouldn't say the single biggest, one of the biggest, right, would be to give them access to information via the internet. So I think that we should prioritize implementation of Principle 37. There's a number of things that can be done. In many African countries and other global South countries, there extraordinary innovations have been implemented to give wider access to the internet. We could look at best practices around the continent, looking at what kind of interventions have the biggest impact, and come up with an implementation guide for Principle 37. What would be the best things or the top things that could be done in each country to make sure the citizens have access to the internet and can exercise their access to information and freedom of expression rights via the internet? I think if we just do that, it will make a big difference. Now, we can just talk about guidelines, but I wonder if I can challenge a colleague, Zoe, to follow up my intervention with ideas of enforcement of access to the internet rights. Thank you.
Thank you very much, Mr. Minar. Zoe, the ball is in your court.
Oh,
So
I'm supposed
fast.
to respond to that. Yeah, I take the challenge because there are many people in this room who are falling over themselves to assist with that challenge. One of the things that we've been speaking about for some time within the African Platform on Access to Information Working Group, a PI working group, was, we've been campaigning for, this declaration. We had very, very specific objectives. And then the next thing we were thinking, what is the taking this campaign to the next level? And that is potentially, a binding mechanism for access to information at the level of the African Union. I don't know exactly how one would go about that, but as I said, there are many colleagues that can help us to get there. And if we speak about access to information, I mean, that access through the internet, through digital technologies, etc. It's just part of that. But the fundamental issue here is about access, meaningful access to information.
Thank you. Thank you, Zoe. I see another hand in the room, but as we go to that hand, I don't know if I have the honor to just acknowledge Honorable Nima Lungangira, who's a member of parliament from Tanzania, and she's just joined this important gathering this afternoon. Honorable Nima, thank you and welcome. On behalf of FES and partners, thank you.
Good afternoon once again, everyone. I think the question you asked... Hello?
Sorry?
I think it's my turn, Chief. Thank you. I'm sorry.
I'm so sorry. Go ahead.
Madam Moderator, I won't respond to your questions, very difficult questions.
Thank you.
But I wanted to react to Professor Mari's input earlier. Something he said triggered a memory in me of a conversation that took place earlier this year, hosted by UNESCO, regarding possible regulation of digital platforms. I noticed that this year, 12 African countries are going to have national elections. In 2024, 12 countries are also going to have national elections. So that's almost half of the countries on the African continent. What I would like us to discuss is what is the role of digital platforms? What is their impact on elections? And what can we do about it? I'm raising this because Professor Maria indicated an idea around running audits, algorithmic audits, or audits on AI systems. And I would like us to take up that suggestion by using some of the tools that we have at our disposal. For example, access to information laws. Is it not the right time for some of us in civil society to begin to make requests for information from tech companies regarding the types of algorithms that are being deployed on electoral systems? Not to get information about how they work, because some of that could be proprietary information, but just to know what kind of algorithms have, or what's the number of algorithms or systems, AI systems have been deployed as part of running elections. And how do they work? How do they influence how a person exercises their right to vote? That's the first part. The second part is it not the right time to start holding digital platforms accountable in terms of their own privacy policies? Because we do know there's a lot of abuse, particularly around election time, where information gets collected, information gets transferred, illegally. So should we not be starting to think about looking at those privacy policies so that when they start to act, we are able to hold them accountable in terms of their own policies. But now these are things that I think should be done by civil society. Of course, regulatory authorities are there to give muscle where it's needed, but these initiatives need to be led by civil society, I believe. The last point I wanted to speak to was the issue of not enough work being done to study issues around algorithmic bias. I think I would like to suggest a few sources, particularly the Algorithmic Justice League led by Dr. Joy Bulamwini at MIT. They've done excellent work. Some of it has been captured in the movie Coded Bias, where they show how issues of oppression, issues of racism comes into play in terms of development and usage of algorithms. Of course, there's the work by Professor Sophia Noble, the algorithms of oppression. So we have a lot of this work that we need to look into and see what it means for us as we begin to develop some kind of strategy to engage with digital platforms. Thank you, Chair.
Thank you. Thank you very much, sir. Your point really echoing the discussion that was happening in Prof. Mare's group on building coalition in finding the results that we're seeking for. There was another hand, two hands.
Okay, thank you very much for that.
You.
But to an extension to what he has talked about, it's always, there is no yes or no response to what you have said, considering the peculiarity of the continent and our experiences in similar agenda in the past. But I would just want to draw our attention to how we can learn from our experiences to develop a more, maybe a more effective strategy to be able to actualize what you said. Consider the fact that within the continent, different countries with different peculiarities, we may at the end of the day not actualize the same model for all the countries within the continent, but at least if each countries within the continent is able to achieve some of these, the openness of internet and inclusion of internet in relation to their own peculiarities, I think we will say we have made significant progress, because I will assume that when the issue of the agenda of freedom of information was being raised, when the agenda started, similar questions must have been asked on if that particular agenda is going to be achieved. And you can listen to what the previous speaker has said about the percentage of legislation that we've had as regards to access to information in Africa. And that's at the legislation stage, not even the implementation stage. So it's a long way to go, and I think learning from our experiences could actually help to drive a very effective strategy to achieve that. Thank you.
Thank you. Is there another hand in the room? Yes, I see two hands. Honorable, please take the floor.
Thank you. My name is Nima Lugangira. I'm a member of parliament in Tanzania, and I'm going to respond to the issue about, the internet and the impact on democracy. Definitely. I think we all agree that the internet, access to information, has an impact on democracy. And it is important for democracy because it gives opportunity for citizens to know the different parties and the different candidates, what they're saying, but it also gives an opportunity for us as politicians to get direct contact with the different people that we're trying to get votes from. However, I think it's very important to understand and to recognize that the online environment is not conducive for everyone in politics to be on. And I'm speaking as a female parliamentarian. It is extremely difficult for women in politics to be online. So when we're having these discussions, when we're talking about one side of the coin, I think it's very important to recognize that currently the online environment is not safe and it's not conducive for women in politics to be online. But even the African Union, the statement on recognizing digital violence on women, it ends there. Oftentimes, when we're talking about online violence on women, there's a lot of attention and focus on women journalism. which is good, women journalists. And over time, it has grown so that it has been recognized that female journalists endure online abuse. But no one, almost rarely, do we think about women in politics. So I think it's very important to recognize that in these discussions, we must also look at women in politics. And when we are being abused, we are being told that we need to have thick skin because we're in politics. Or when we're defending ourselves, we're being told that, oh, you politicians don't want people to criticize you. So there is also a thin line between this freedom of expression, freedom of speech. Where does it end? At what point does it become abusive? So I think when we're talking about the issues related to digital democracy and the impacts, we should recognize that we need women in politics online. We need to increase the online visibility of women in politics. But right now, the environment is not conducive. And I think it's those of you who are in this space need to make sure that it is conducive. Thank you.
Thank you very much for that intervention and refocusing on the issues of rights. And I hand over, is that our last contributor, Ndishishi? Yes. Thank you.
Thank you very much. Good afternoon, everyone. Or is it good evening? Okay. My name is Ekene. I work with FES Nigeria. And I wanted to re-echo something that came out strongly in my group about meaningful engagement, but in the right spaces. There was this recommendation that UNESCO and the African Union needs to work together to put up some sort of a repository of spaces that matter, where decisions around the continent are happening on information and communications rights, and probably maybe 1 or 2 year line of events that these spaces are hosting, so that we, the actors who are in this room having these discussions, could then go to those spaces and engage. This is particularly very important because even in lawmaking in our countries, like someone had mentioned, those who are making laws are not so conversant with what issues they should be addressing, right? And since it is difficult to bring them to these spaces where we are, maybe it's time we engage those spaces. Whether or not that becomes productive is a different conversation altogether, but I think increasingly that recommendation needs to be very out there, and because I know that we have Lydia in the room and colleagues from African Union, I'm sure they'll be able to take that up. Thank you.
Thank you very much, sir, for that last contribution. Really appreciate it. As I say goodbye, I would like you to raise your hand if you believe that an open and inclusive internet for Africa is a possibility. Great. This brings so much hope and makes this conversation very relevant on where we have to go. So we hope that with all the coverings that we did from policy, again, for cohesion, from priorities at government level, but also at community level, from our own advocacies as human rights defenders, activists, and of the internet, we just have the work set out for us. Thank you very much, and thank you for letting me moderate this session. Thank you.
Thank you so much, Nashilongo Gervasius, for a very, very insightful session. How was that? How are we feeling? Can we continue? I don't want to wrap up the conference. Can we continue with the conference? Huh? I think we can sleep here tonight, yes? Ladies and gentlemen, thank you so, so much. I want you all, first and foremost, to give yourselves a very warm, resounding round of applause for the amazing work, the amazing contributions that each and every one of you have done today. Hopewell, you disappeared for a bit of the day. We hope to catch up with you as, of course, the days unravel. But thank you for returning. We really appreciate it. I had initially crafted something, well, fairly okay to wrap up day one of this particular conference. But after listening to you, brilliant ladies and gentlemen, I feel I'll be doing a disservice to the contributions and the input that has come from this first day of the conference. But I really just want to first and foremost thank, that is, the Friedrich Ebert Stiftung Namibia office for really once more coming up with this wonderful initiative. And listening to these conversations, I'm excited, I'm eager for what's to come tomorrow and Friday specifically. And I can see it on many of you guys' faces as well, that you're eager too to see what happens tomorrow and Friday, of course. So once more to Ms. Freya Grunhagen, thank you for the work that you've done, and of course to the team as well. Ms. Zoe Titus, the Namibian Media Trust, continuing to, of course, put media at the forefront, and of course also supporting this particular regional conference. Thank you for your inputs. Thank you for your earlier statement. I think also just hearing that is from our special rapporteur earlier on in the day, as well as from that is Jafar Musa Al Kadum, our head of office here, the UNESCO Namibia office in country rep. I think the support is there, and I think definitely we can look forward to a very, very promising conference. What's also most important to note about this particular conference is that it is working towards crafting a declaration that would look at fostering information and communication rights in Africa. So I think it's really important that we keep bringing those recommendations, concrete recommendations for that. As always, looking forward to delivering that statement on Friday, I'm sure. Our rapporteurs, are we happy with the day? Are we happy with what we've received so far? 100%. That's good to hear. Of course, Robin Tyson is making sure that each and every valuable input is captured, and he's just been typing away at that keyboard the whole day. I feel so sorry for that computer. Eh? Ladies and gentlemen, of course, we look forward to an exciting morning, afternoon, that is tomorrow, day 2 of the Regional Conference on Information and Communication Rights in Africa. We want to thank you all so much for showing up. I'm pleased to see so many people at this hour still. Usually with African events, and I'm going to whisper a bit, people tend to disappear, but it's really good to see you guys still, eager for this particular conference. So we meet tomorrow morning starting at 9 o'clock, not too bright, and we hope for a slightly warmer morning tomorrow. But please, we do hope that you enjoy the rest of your day, that you enjoy the welcome reception dinner that's planned for you. And also, just before we leave this particular venue and go back to our rooms, for instance, please just note that we will be taking a group picture outside, just here on the lawn. So please make sure that you, of course, do bring your best smile for that. I'm sure Maxwell and Isak, who I think are the best dressed gents and overall participants for today, are eagerly looking forward to that photo session. Please, a warm round of applause for them. Yeah. Nigeria came to show out. Eh? But yes. All right, yeah, so there will be dinner tonight, a small welcome reception. We had a smaller reception yesterday, but many of you couldn't make it, unfortunately. But there will be something similar happening today as well at 6:30. That's about in an hour and 10 minutes time here at Oryx 3. And you can, of course, grab some more delicious food. And I hope many of you this time around go for the beef. Namibia has some of the best beef. It's so good that there's a rumor that people who tend to eat Namibian beef end up not brushing their teeth for a week. I wouldn't advise it, but it's that good. That's how good Namibian beef is. Ladies and gentlemen, thank you so much. My name is Ndishisha Mfungu. Selma Moses, our sign language interpreter, for making sure that, of course, our message is conveyed. And I just want to wish all of you the best for the next 2 days. And I think, definitely today did set some very good precedents for this conference. Thank you once more.